right, good afternoon. We're continuing D1010 2024-13, State of New Mexico versus Alexander Ray Baldwin. Party, state their name.
Kari Morrissey and Erlinda Johnson on behalf of the state of New Mexico.
And on behalf of Mr. Baldwin, this is Alex Spiro. I'm joined by Luke Nikas, John Bash, Sara Clark, and Heather LeBlanc. Good afternoon.
Good afternoon. All right, we are going to do a cross-examination and defense wherever you feel that you need to begin your cross-examination continuance, including at the very beginning. Go ahead.
Yes, Your Honor. I appreciate that. Given what occurred last time, I'm not going to make a voluminous record at this time, just reserve my right to make record further. Hopefully we can get through this. I hopefully don't have much more because of the voice intonation and the email from the prosecutor. I'm just going to ask the question since he hears my voice. So good afternoon, sir. Mr. Haag, can you hear me?
I can now.
And is my voice clear for you, sir?
Yes, it is.
Perfect. I'm going to try to go through this as quickly as possible with you, sir.
So let me understand, is Ms. Clark not, where's the echo coming from?
I was going to try these at $370. They're not working. They worked a while ago, and I listened to a file. I don't know what.
It's okay. Just put him down. If you can hear Mr. Spiro, we'll be asking the questions. As long as you can hear him, you don't need the headphones. Your Honor, the reason I believe that Ms. Clark is not continuing the cross-examination is because I explained to the defense over the weekend, and I did also send the email to Faith, that because of what Mr. Haag has done for a living, he suffers from high-frequency hearing loss. So he is unable to understand Ms. Clark because of the high pitch of her voice, while he is able to understand others. So the defense has decided to remedy that by having Mr. Spiro ask the questions. I certainly have no objection to that. I welcome that. Thank you.
Anything additional, Mr. Spiro?
No, I don't need to make a further record at this time. Hopefully this can proceed, and I will have a record to make after the testimony. I don't think we need to jump the gun, and I know the court will give me an opportunity to make a record if and when necessary. Thank you. May I proceed?
Yes.
Mr. Haag, just to orient the court, you agree that the testing that the FBI and Mr. Ziegler did, the destructive accidental testing, was unnecessary in light of the circumstances of this case, correct?
I would view it as unnecessary given the context of the case.
I'm going to put up very quickly the prosecutor's Exhibit 80, which we looked at before, and hopefully that works efficiently. Right? Great. As you spoke about, and just to orient the court, the notch closest to me, the full cock notch, this is where at the very bottom of it, or the left side of it, there is something missing, the notch. That little piece, and a piece of that was actually missing when you received the hammer after the destruction at the FBI, correct?
That's also correct.
And the testing that you did, sir, was to isolate the damage to the hammer, fair?
Yes.
But the sear, which is what I want to turn to now, the sear is another important part of the firearm, correct?
Yes, it is.
The sear is the top of the trigger. The sear is what engages with these notches in the hammer and what catches within those notches, fair?
Also correct.
The sear is about the size, I think you said last time, of the tip of a screwdriver.
A screwdriver.
So the way that the sear interacts with the hammer is that it can engage with the notches in a very precise way to stop the firing from happening.
That's right.
And if you were to change the depth of the sear, the angle of the sear, a piece of the sear off, it could have an impact. Fair?
It might.
And if I asked you, if I gave you a firearm and said to you, take the sear out of the firearm and file it or change it, how would you do that?
I'm not sure what my purpose would be. Can you clarify what would be my intention of doing that?
Forget your intention for now. If you were to file it, how would you do that? Or you can't answer that. You're saying to me you can't possibly answer that question without knowing the purpose of the alteration. Let me ask you this. You can and have, when you disassemble firearms, taken the sear piece out, correct?
Yes, anytime.
Now, the testing of this sear, and we can take this exhibit down, the testing you did where you replaced some of the parts in the firearm and isolated the damage to the hammer, you couldn't do that with this sear because of the way it broke off, correct?
Yes, that's right.
You viewed any attempt to do so as pointless, effectively.
Yes.
But you did observe damage to that piece of the sear, correct?
Yes, it's broken. That's damage.
And you observed what you called egregious marks that have an angular component on the actual sear itself, true?
On the working surface, that was observed much later, but yes, you're right.
You reported it much later, but is it fair to say, as I think you testified to last time, that in July, when you went to do your report and you went to examine the firearms, you and your son ended up taking these firearm under a microscope and you observed it then?
That was at the end of a lot of other examinations.
Understood. And beyond the other examinations, you also reviewed materials. You had many binders from the prosecutors of materials, correct?
I had a box full of binders.
And you can always, as you've been doing this for 50 years, you can always ask for more things.
If I don't see what I need to get an understanding of the issues, I would ask for more.
The prosecutors can give you more things.
I haven't been refused so far.
So when you did your first report, and we went through this, you did one in August and then one in late August that did not include any observation of the marks, correct?
That's right. There's actually 3 in August, it turns out.
Right. The first 2 in August, just to make sure it's clear, you do not talk about, indicate, or notice these marks. And in the third report, you do, correct?
Yes.
But it's fair to say you didn't go back to viewing the firearm or the piece between tests 2 and reports 2 and 3. You had noticed earlier this marking on the sear, correct?
I had photographed it a lot. Actually, my son had photographed it a lot, but I hadn't given it much thought until the testing resulted in the second report.
But after the second report, it obviously was on your mind, sir.
I gave it some thought, yes, and I thought, document it, final report showing those marks.
And we'll put up that final email and report as it was transmitted, August 31st of 2023, almost a year ago now.
Yes.
Okay, and if we could put up the cover email to that report. And as we're doing that, sir, you deemed it necessary to make a third report, correct?
Not really. I thought it was a useful idea, mainly for the reason that I figured somebody, another AFTI member or another competent firearms examiner might see that and wonder, why didn't I point it out?
Sir, you found it necessary enough. You did it. You did the work.
I did the work.
You charged the state of New Mexico for it, didn't you?
I'd have to look in the billings.
You have no reason to think that you did this as a pro bono third report, do you, sir?
I've forgotten your last name, but I spent a lot of time on everybody's case. It never ends up being billed. I can't.
Okay. You can't tell me. Okay. And my name's Alec Spiro, just so you have it if you need it.
I don't know how to pronounce the last name.
Spiro. Your son, who's an expert in his own right, agreed that this report should be done and sent, correct?
Yes.
You sent it to a prosecutor in an email, correct?
Yes.
Agreed. No other prosecutor other than one prosecutor, Miss Morrissey, correct?
I think there's several attorneys involved for the state. She is the person to whom I regularly deal and receive requests.
By sending that, you discharged what was on your mind in terms of the notice that you gave in the modification of what you wanted to document in terms of that modification.
Yes, the reason for it.
The reason for it. Okay. The reason for it. The report had 7 pages, figures and images, comparative photos.
Just take a moment and review it.
I guess I'm just wondering if, just for the record, if there can be an announcement about what exhibits we're looking at.
I did make an announcement. This is Defense 3.
Oh, I'm sorry. Okay, Defense 3, that includes the email and the report?
It does.
My apologies.
Not at all. If we could just scroll to the bottom. There are different figures, right?
Yes,
Comparisons. It's 7 pages. You saw that?
you've gone rather quickly, but I see the figures. If we want to stop on, we'll go.
Yeah, well, you see the bottom, it says page 7.
Yes,
Yeah, it was longer than your second report.
I haven't counted the pages.
If we could go back up and to the signature line, you signed the report, your son signed the report,
Yes,
and on the cover it says First Judicial District, State of New Mexico. You knew this report could be used and presented in court, correct?
I'm not sure how it might be used. It would inform the person that hired me that I did look at these particular marks later under the microscope. As you've already seen, felt it appropriate to put it in a report of some sort for the reasons I previously stated.
It could be used in court potentially at some point, correct?
I'm not sure. That's not my call.
I know it's not your call, sir, but you're one of the most experienced experts in firearms in the United States. Do you not? That your reports can end up being part of court records. You do know that, sir.
I know they can be, but not necessarily will be.
But can be. And in this report, you indicated that the off-axis or diagonal tool marks of an unknown origin, it seems unlikely, although it cannot be excluded, that these tool marks are the result of the damage incurred during the FBI's impact testing. Correct?
Yes, you read it correctly.
Okay. And when you say the word unlikely, you obviously mean it's less than a 50% chance. Fair?
I'll agree to that.
When you say the word unlikely, you obviously also don't mean a 0% chance. You mean somewhere in between, say, 10% and 40%, somewhere like that. Is that fair?
It's not necessarily fair because I wouldn't give it a numerical value, but I stand by the statement made at the time.
But let me just ask you this to the best that you can. When you say unlikely, can you just tell me what you mean by that?
Yes, I have a thorough working knowledge of how this kind of firearm works. I've looked at them many times, and I fully expected if the force delivered to the hand by Mr. Ziegler was in a back to front alignment, those shear marks, those rough marks that we're now talking about, would also be in a front to back. I didn't know how he had done his test. I didn't really know or have a good idea of the history of the gun, if it had ever been used somewhere else or worked on at the time. So it was the appropriate statement at the time based on how this gun works, but my lack of information.
Yeah. The word unlikely is all I'm focused on. What do you mean when you say the word unlikely? Just so I understand in a report.
The likely way such shear marks would appear would be in a perfectly back to front or front to back, but not on a diagonal. There has to be a force that's coming in at something other than straight on if that breakage occurred, if those marks were deposited during Mr. Ziegler's final testing.
Yeah, let me try a third and slightly different way. Forget the testing and what you claim to learn later. I'm just asking, when you put words in reports about the likelihood or unlikelihood, here there's a phrase, although it cannot be excluded. You have phraseology like that in your reports. I'm just asking about the word unlikely. What do you intend for it to mean?
It was the appropriate assessment at the time I wrote this report.
Yeah, I'll try one last time, which is, I'm not questioning whether it was appropriate, okay? I'm just asking you, what are you intending to convey with the word unlikely? Some experts use beyond a mathematical certainty, highly unlikely. I'm just trying to understand the phrase, the word unlikely.
I think you're reading too much into it. I just meant it for what it says. Simply based on what I knew about how these guns work, I felt it was unlikely that the breakage shearing off of the sear tip of the trigger would cause marks that would have an angular component to them.
You do agree, and you write here, that these marks do not appear to be original manufacturing marks. True?
Very true. Yes.
Okay. There was evidence here of modification or damage. Fair?
Yes.
The sear did not look 100% as expected or normal.
No. If it's only viewed in the macroscopic view, there are 3 or 4 photographs that show that. I wouldn't notice marks on the working surface, and simply putting the 2 pieces back together, the dimensions are correct. The tip is still at right angles to the axis of the trigger. So it looks normal until you look at that area under a high-powered microscope.
And at that point, it doesn't look as normal or expected, correct?
You're right. It does not.
No one rushed you in preparing this report. No one prevented you from requesting other information for this report as you formed your opinions.
Not that I recall.
You received the list of items that you asked for at the top of your first report and continuing throughout this case when you requested them. True?
Yes.
I'm not going to keep staying on this report. We, as you noted, it's an August report, August 31st of 2023.
Yes.
That's an easy to remember, the last day of August of last year. Fair?
Yes, it is.
Okay, we won't keep the date up then. We can take this down. Earlier this year, you testified in a homicide trial in the very same courtroom for the armorer Hannah Gutierrez Reed. You recall that?
I do.
Okay. So at that time, many months after this report, many months after your observation, you were asked, other than the FBI testing, breaking those components, you didn't see any other evidence of modification or damage. You said, I did not, right?
I don't recall, but if you're reading the transcript, I don't dispute it.
If you gave that testimony at that trial, that would not have been accurate, correct?
I'm not sure. I guess I'm missing something. I hear you just fine, but I'm missing something in your question.
I don't think that you're missing anything. I think sometimes people say things that are inaccurate in life. Okay. So I'll read it again if you need me to, but I think you and I both know that it's inaccurate because you just told me a moment ago that you did observe modification or damage. The question I just asked you was the exact same question of what you knew August 31st, 2023. Now, here we are later in time at Hannah Gutierrez-Reed's trial. You were asked, so other than the FBI testing, breaking those components, you didn't see any other evidence of modification or damage. You responded, I did not. That was not accurate, sir, correct?
No, I think it's perfectly accurate. We're missing.
Well, you saw no evidence of any modification or damage on this firearm, on this sear, outside of the FBI testing? You just wrote a report that said earlier and just told me under oath that your report indicates you did see modification or damage that was not likely caused by the FBI, didn't you?
I guess you've got me well confused at this point. I don't see the difference.
You don't see the difference between saying on August 31st, 2023, I quote unquote see no evidence of modification and damage, that on August 31st, 2023, evidence of modification or damage that is not attributable to the FBI in your estimation. And then at the trial, okay, mistaken or not, sir, it's easy to just say you made a mistake if you made a mistake. You told the jury that you saw no evidence of modification or damage. True?
Yes. If you're reading
And that
it,
was a mistake.
and
And that's a mistake, correct?
it's giving it further thought, and it just had to be a consequence of the FBI work and the way Bryce Ziegler used his mallet on the hammer. There's no other.
No, sir, the Ziegler stuff didn't happen until the last week. Okay. I'm going back in time to the jury trial that happened before Her Honor, where way before you ever spoke with Mr. Ziegler, way before. Okay. You did the report, you stood by the report, and you testified under oath the opposite way as to this one issue, and you made a mistake when you testified in Hannah Gutierrez-Reed's trial, correct?
I don't believe so. No.
Explain that to me, sir. How you just told this court that you did see evidence of, quote, modification or damage not attributable to the FBI. Then you told the jury that you saw zero evidence of modification or damage. That was a mistake, sir. It's okay to admit a mistake.
Sounds like you're testifying. It was not a mistake. It was my opinion at the time of trial. As I recall, I now had information, not from talking to him, but from an interview of Mr. Ziegler by the prosecutor. I then, by the time of the trial, learned that he used no apparatus to conduct his impact test. He did it by freehand, and right away, as soon as I knew that, there's the opportunity for an angular component to his wrapping of the hammer. That would explain it.
Mr. Haag, do you remember when you testified before the court on Friday, just a couple of days ago, you confirmed that the first time you ever spoke to Mr. Ziegler was a week ago?
That's true, 17.
Okay. That was the time where you learned new information that caused you to change your opinion. Nothing caused you to change your opinion, as you testified on Friday, until you finally were in the room with Mr. Ziegler many months after Hannah Gutierrez-Reed's trial. You just told this court this one business day ago.
No, it's true. I did not have a face-to-face by Zoom with Mr. Ziegler until the 17th, but I was now aware by the time of the trial of his methodology. It was not clear in his notes. Prosecutor interviewed him or asked some questions and relayed that information to me. That left those diagonal marks fully explainable, only explainable by the impact test.
If this is the opposite.
Hang on, Your Honor, I have a request. If we were doing this hearing in person, what would be happening right now is Mr. Spiro would be showing me a copy of the transcript that he's referring to, because the court would require him to do that. Would it be okay if can he email me the trial transcript that he's referring to? I have no idea what he's referring to, and neither does Mr. Haag.
Okay, so let me just say this, okay? If a prosecutor is listening to testimony that a prosecutor knows is false, a prosecutor has an obligation to correct it, okay? That's the first thing I'm going to say. The prosecutor in this case knows full well that what Mr. Haag, whether it's faulty memory or intentionally, is saying is incorrect, because he has, over the course of the last 3 weeks, confirmed many different times that the only time he changed his opinion was a week ago. This testimony that he's given.
Stop, both of you.
I'm
You're
just
going to
asking for the
continue.
transcript.
You're going to continue. You're not going to get the transcript. I believe he's testifying from a transcript, but I'm going to assume it's in good faith that he's using the quoting from the court. So we're going to move on. So go ahead.
When you said the fourth day of the trial at 15 to 18, when you said that statement at Hannah Gutierrez Reed's trial, nobody corrected that statement, correct?
I don't even recall testifying to that, so I can't answer.
Okay, but you don't recall anybody correcting it either, do you?
Why not?
And about that, what your son Mike testified about in front of the grand jury regarding this issue. Do you know that?
I don't have a recollection of it. I read it at one point in time, but I don't remember any of it.
When later in time, after the Hannah Gutierrez retrial, you testified, you sat down for a pretrial interview in the Alec Baldwin case. You remember, because you said you remembered Miss Clark. You didn't remember anything else, but you remembered seeing Miss Clark for the pretrial interview. You remember that?
I do.
And you knew it was important to tell the truth?
Of course.
And Miss Clark even told you, make sure you tell the truth.
I don't remember that.
Okay. At that time, you said the seer looked as expected and normal.
I did.
Okay. I don't know. You said you don't remember that pretrial interview at all.
Excuse me, Alex. I do now because I was sent a copy of it. I didn't have one, and I viewed it this morning. Much of it came back to me.
You know that's improper, sir, while you're on the witness?
I'm just trying to help you out here.
I appreciate that. If you just answer my questions honestly, that'll be the best help for both of us. But I'm asking you a different question, which is, do you know whether or not that's improper?
What's improper?
That while you're on cross-examination, you are not to receive materials from one party and do anything with them. Do you understand that?
No, I don't. I wanted to know, since I couldn't remember that interview, what the questions and answers were. Simple as that.
Do you remember? We'll go back to that and we'll put a pin in that. Let me ask you this. You've been an expert witness for 50-some years?
Yes, I have.
And you don't know that while you're under cross-examination, you're not to be speaking to the party calling you and getting information from them? You don't know that rule?
I'm unaware of what you speak.
Okay. Do you remember live in front of you at that interview, the defense learned for the first time that there were additional reports involving this case after your initial report in this case? Do you remember that?
I do now.
And it happened live in front of you because you said something, right, spontaneously, that caused the defense to realize, oh my goodness, there are additional reports. You remember that happening, right now?
Yes, I do.
You have said in this courtroom that your understanding from the prosecutors was, and I quote, that the reason we didn't have the additional reports was a, quote, breakdown in communication. Do you remember that?
I don't remember that specific line of questioning. All I know is it got resolved by the end of that interview.
Actually, it didn't get resolved by the end of that interview. Because don't you that later, after more spontaneous statements by your son, we learned that there was a third report that casted doubt on everything you all had been saying in front of Miss Gutierrez Reed is at her trial and in front of the grand jury at your previous pretrial interview, which is why you got called back. Which is why you got called back.
Ask questions. Please stop testifying. Thank you.
Did you learn at a later point whether the third report was eventually turned over to the defense? Did you learn that?
Yes, I did.
I think you started to say this earlier, but you volunteered that the reason that you wrote the third report was because of this anticipation of cross-examination. Is that your testimony, sir?
No, it was anticipation that a colleague, an AFD member, or maybe a private person suitably qualified, would see some of the many. There were 3,900 photographs that Mike and I took, would see those marks, wonder, what did Luke think about those? Did he notice them? So I put it in that report, that third August 31st report.
There are certain things that are de minimis that you could be asked about on cross-examination, or a word you could change in a report. This to you and your assessment of what another expert would think was sufficient for you to do a third report. Fair?
It was a stimulus for that, whether it was needed or not. I just felt I've been down this trail so many times and I don't know what a person did. I can't tell necessarily from their worksheets. This case is an example. Photo documentation notes are really important. And there are lots of pictures of this reassembled trigger and sear to ultimately include photomicrographs of the working surface, the thing we've been talking about now for half an hour.
You presumed Your presumed oversight, you thought, would allow this to go in an untoward direction. That was your phrase. Presumed oversight, if you didn't make this report, could go in an unfortunate direction during your cross-examination.
I'll have to reread it if it says that. I don't recall.
Can you demonstrate for me prior to Mr. Ziegler's meeting, which we're about to turn to, that happened a week ago? Can you just demonstrate for me how you understood the hammer test to be?
Sure. The revolver was mounted in a fixture. That's great. So it isn't going anywhere. Hammer at full cock position, and then he's freehand swinging a rawhide mallet. Couldn't remember which one or what the weight of the head was. Multiple times against the hammer. He conceded that there was no way, he couldn't be sure it was perfectly front to back in this axis, and that it finally failed. And when he took it apart, the sear tip was broken off.
After your meeting with Mr. Ziegler, can you explain to me what your understanding was of the mallet test?
I didn't have a meeting with him. I saw him on a Zoom arrangement, and the questions had been asked Morrissey, and I asked at some point, could I clarify that? I was allowed to do that.
Your understanding after that meeting, how did it change in terms of how he hit the gun with the mallet?
I never knew exactly how the gun was mounted and how it was struck. It wasn't in his note.
That's not exactly my question. I'm going to try again. How did what he described, can you now demonstrate for me what your understanding is now?
I just did in an unorganized way. It wasn't in a fixture like a pendulum. I built a device that will do this so it keeps the angle perfectly straight and we can know the actual force of impact. Don't know any of those things concerning his rawhide mallet test.
Right. I'm now getting confused. I had asked you before what your understanding was prior to meeting with Mr. Ziegler. Okay. I'm now, pardon?
Sorry, thought you were through.
I'm now asking what your understanding was after you met with Mr. Ziegler. You don't like the word meet for some reason, that you saw him on Zoom and spoke to him. Okay.
Object to the form of question. He keeps asking 2 and 3 questions in one question. Can we just have a simple question, not a compound question?
If Mr. Haag is confused, he can ask for clarification, but let's try to limit the compound. Thank you.
I believe so. I had an understanding from a previous interview, of which I was not a party, but heard the written results or noted results from an interview of Mr. Ziegler I believe by Kari Morrissey. He was using a rawhide mallet and a freehand motion. And we had that Zoom meeting on the 17th. That's what I wanted to clarify. There are ways to fix a mallet in a pendulum-like fixture. I'm pretty sure at this point, we're talking about a freehand swing of unknown impact at an unknown angle. That was verified in the June 7th Zoom meeting.
That's when you first learned that, fair?
Learned that a refinement of his impact testing as to how he did it.
It was after that time that you took back your conclusions in the August 31st report, correct?
No, I think by the time of trial, I had enough information that of the impact testing that was the only logical explanation for the diagonal aspect of the marks on the working surface of the broken.
When you sat down with virtually Mr. Ziegler, Miss Morrissey gave you some dates.
Sorry, Miss Morrissey
Gave you some dates to choose from to sit down with him.
to ask questions. Yeah.
Did you get the impression that he even knew he was showing up to that meeting to see you or to see Miss Morrissey and you?
It became pretty apparent.
Action speculation. He's asking Mr. Haag to speculate about what Mr. Ziegler thinks.
It's a proper question. I'm asking him if he had an impression.
Okay, it's not asked correctly, but it sounds like Mr. Haag is going to answer something about being a parent. Let's let Mr. Haag answer that question.
Yes, it was pretty apparent. I could see him, he could see me, and he gestured as to how he swung the rawhide mallet, struck the hammer.
Okay, so you were there in this meeting and it was about an hour. Is that fair?
Probably.
Okay. There was no parts of guns at this meeting where you all were looking at parts of guns under microscopes and things like that.
Not at his end. I may have brought mine for a demonstration. I don't know.
You don't remember?
I don't remember if I produced mine. He certainly didn't. I remember him sitting in an office with a headset on.
Okay. There was no additional, let's just leave it at this. There was no additional testing done at this hour-long Zoom meeting.
You're right.
And can you show me how he demonstrated doing it at this meeting?
I don't have a mallet here with me, and my mallet isn't rawhide.
Just approximate. You don't need to. Just show me the motions that you remember him showing you at the meeting.
I'll do it again. Hammer fully cocked, gun is mounted, can't go anywhere. It's in a fixture of some kind, similar to a device called a ransom rest. I know I asked him if he had a ransom. It's it's a brand name, Ransom Rest. Said, no, it's by another company. Then he just showed with his hand, swinging the mallet freehand, no particular measurement of the angle or the impact force, nothing quantitative about his test, a totally subjective assessment as to whether he was hitting it straight on or not. And I think he said after several blows, it broke.
Did he tell you how many?
He may have. I can see some evidence in the step on the hammer at least twice before it broke.
But I'm asking not from what you saw, but did you ask him how many times did you hit it?
Probably, but we'd have to go back and listen to it. Multiple times is all I was interested in. Then it broke.
Is there a recording of this meeting?
I don't have one.
Do you know whether one was recorded?
I do not.
Do you know whether anybody took any notes?
I don't know.
Can you just demonstrate how he showed you his? I take it that the main difference here is that you had an understanding about sort of a perpendicular strike with the mallet, but that you come to now say you learned that it could have been human error or what have you, or what he shows you, more of an angle. Can you just demonstrate that for me so I can understand that?
Once again, let me hold it up this way. Bottom to top, let's just call that parallel. Came in from this way, parallel with the long axis of the barrel, as opposed to coming in at some slight angle. And he conceded that there was no fixture, no special apparatus to deliver the hammer blows, the mallet blows, perfectly parallel to the axis of the bore, to the spur of the hammer.
That was different from your prior understanding. How?
No, I didn't have in August 1st and before, I didn't have an understanding from his notes, and I didn't feel it appropriate to call or talk to him since he was a witness in the criminal matter with Gutierrez Reed.
But if you couldn't talk to him before the Hannah Gutierrez retrial, why did you decide that you could talk to him before the Alec Baldwin trial? If you couldn't talk to him because he was a witness?
Because the defense, your side, is making a pointless red herring issue about these marks on the sear. Just take the view that they were there at the time of the incident. The gun worked fine. End of story as far as a forensic analysis goes. I really don't care where the diagonal marks came from. They're not polishing marks. They're not the result of a trigger job. They're a result of damage. The only damage that happened to this gun was Bryce Ziegler's hammering on the hammer. If they were there, as I said, at the time of the incident, got a correct trigger pull, the gun repeatedly worked. So in my view, as a forensic scientist, this is a non-issue.
Okay. In your 50-year career, had you ever had a gun destroyed in this manner?
Have I ever had a gun do what?
You basically just told this court that this is to you an insignificant matter. I'm asking you, is there another case, a homicide case, a case of this importance, where the FBI or law enforcement has performed an unnecessary test and destroyed the gun at issue? Has that ever happened before in 50 years?
I don't remember such a case.
Okay. You also don't remember such a case in which you ever saw this type of damage on a sear before, correct? That was the first time you had ever seen damage like that on a sear, correct?
That is correct.
We've pulled some of your old cases and looked at them, but is there ever a case that you've ever had of this importance where your third report or any report you gave that cast doubt on your conclusions was not provided to the defense in a homicide trial? Has that ever happened before in your career?
I have no idea.
When experts don't provide, and I'm not blaming you, sir. I saw your email to Ms. Morrissey. I'm just saying to you, when experts don't provide exculpatory reports in homicide cases, those are oftentimes the kinds of things you might remember if you were the expert involved, don't you think?
Objection to the form of question.
No, I leave those issues to
Overruled.
Wait, Mr. Haag, sorry. Sorry, Judge.
I overruled your objection. Go ahead.
So just to maybe make it a little tighter, you can't tell me that of a case in which an exculpatory report that you provided was not disclosed to the defense before a homicide trial. Of no case.
I know of no case.
I am objecting to the form of question because it presents facts, not in evidence. The question presents that the report was exculpatory. This report is not exculpatory. And Mr.
Okay.
Haag hasn't said
Okay,
that it was.
I think you can do this on redirect. Okay, thank you.
We're going to provide, we have an affirmation from Mr. Bowles' office that if we could just, I know I can't approach the bench, but I'm going to ask my colleague to send over to Faith, if that's okay, an affirmation saying that he never received this report before the Gutierrez retrial.
I'll stipulate to that. He didn't receive it because I didn't send it to anyone. That was my error. I thought I had and I hadn't. Stipulate.
You've testified previously that sort of two main buckets of information came out of your meeting with Mr. Ziegler that changed your conclusion in your August report, correct?
It allowed me to have now a certainty as to how those diagonal marks occurred. It left that as his work, his test as the only explanation, only plausible, reasonable explanation.
I think you gave two reasons for changing your opinion at the most recent PTI. So tell me if I'm wrong. One was you learned more information about the history of the gun. The other one was Mr. Ziegler's description to you of the manner of hammering. Is that fair? Okay. In terms of the first reason, what was new that the prosecutors told you at the 1 hour meeting with Mr. Ziegler, the remote meeting with Mr. Ziegler, you testified, as I understand it, that you learned more of the history of the gun from Mr. Pieta forward, and how it came to be with Seth Kenny and then on the set of Rust, right?
Well, it's a little more than that. It's also the interview of Seth Kenny, Mr. Pieta, and some information from MF, as I recall.
Okay, and you knew this was a one-off gun. There was only one made before it was shipped to America without a firing pin.
Yes.
Okay. It's actually true that you actually had viewed Mr. Pieta's testimony in May, a few months earlier than this.
Yes.
Okay. Then the other thing that you did, and we did in court too, is you watched a bunch of videos of a movie set and somebody firing what you believe to be this weapon repeatedly in different video clips.
A number of them, yes.
You don't know where that gun was, just to be clear, on October 20th, 2021, or the morning of October 21, 2021. You don't know, sir.
That's right. Not of my own personal knowledge. Others will have to account for that.
Your own personal knowledge, or even from what you've now learned through what we call hearsay, even based on your investigation with the prosecutors, you don't actually know whether somebody had that gun and did something to that gun on that morning. You don't know that, obviously. Okay. So it really then goes back to what you've said about Mr. Ziegler. And you agree with me that even in April, you testified that you knew that he had struck it with a rawhide mallet.
Yes.
Okay. You knew that people, human beings, when they strike things, strike them imperfectly, right?
Yes.
Again, just to put a pin in it, you did not ask him to demonstrate that motion, or did you?
As I recall, he demonstrated it freehand without the benefit of an actual revolver.
And from his standard operating procedures, that there are 6 planes that he hammers on.
Yes.
Did he didn't in this meeting start striking it diagonally repeatedly in some very strange motion, did he?
Object to the form of question. It assumes facts, not in evidence. What does strange mean?
Did he strike? Did you observe him demonstrating for you a striking in a upward, right to left, downward diagonal motion? Did he demonstrate that?
To the extent it involves a cocked hammer, yes. I really didn't care about the other 5 planes, other than it didn't fall from the full cock position.
I don't know if you understood my question precisely. I'm just asking about his demonstration. Did he demonstrate a diagonal strike with the hammer? That's my sole question. Did he demonstrate that for you?
It's a moot point. There was nothing for him to align his gestures with. He had to do it verbally. He conceded it wouldn't necessarily have been perfectly back to.
I understand we just talked about human error and humans are imperfect, and he didn't necessarily strike it back to front. I'm asking a different question. I'm going to try again, then I'm going to ask the court's help. I'm just asking a simple question, which is, did he demonstrate striking with his mallet diagonally? Yes or no?
It's a moot point. There's nothing for him to align his hammer swing with.
Your Honor, if I could get an answer to the question.
Question of whether he struck that way, whether he did that.
I interrupted you, Your Honor.
He wants to know whether he demonstrated a striking to you. You keep saying it's a moot point. Just answer the question whether he did that.
Yes, he did, but without benefit of any prop.
Okay. Why don't you follow up on that question? Yes, he did, without the benefit of any prop.
So he did demonstrate to you a diagonal strike. That's your testimony.
He conceded that it may have had diagonal aspects to it. There was no way for him to demonstrate an angular component without a prop.
So you want to take back the answer a moment ago to the court? He did, or he didn't demonstrate?
Hang on. First of all, Mr. Spiro's testifying The question that was posed by the court didn't contain the word diagonal. That is Mr. Spiro's question. So that's improper.
The video of this and the record will speak for itself. I don't think my,
All right,
so can I ask for
Mr. Haag, you keep answering that basically you don't have a point of reference. So he's just asking, did he strike diagonally?
He conceded that it could have been diagonal. That's the most I can tell you from my recollection of that June 17th interview.
Okay. Now, there's been a lot of testimony about the timing of this virtual meeting you had the week of the hearing we're in front of, right, with Mr. Ziegler and the prosecutors. After that meeting with Mr. Ziegler, you again sat down with the defense for a pretrial interview.
Yeah.
Okay. That was just a week or so ago.
I believe so. A few days after the 17th.
And you said, so again, until recently, I had to keep it as I did in my report back in August, fairly equivocal or neutral in the sense of until I know more that I can rely upon, I have to keep a number of options open.
I think so, yes.
Okay. And that's when you explained, right, that it was really just this week that you have decided to reject your own conclusions in the August 31st, 2023 report.
Yes.
And that you also explained how you had reviewed your son's testimony 48 hours on the same Monday that you were sitting in a virtual room with Mr. Ziegler and the prosecutors. Your son, who worked on this matter with you closely, gave testimony that he stood by the third report, correct?
I read it, but I don't remember any of it. I didn't see anything I took exception with in Mike's testimony.
Break that down for a second. You did read it, correct?
Again, I'm sure I did, but I have no recollection of it because there was nothing memorable about it.
After you read it, you indicated that you took no issue with anything he said, correct?
I would agree with that today. I probably said it then.
Okay. We will represent to you, and we can put it in front of you, if you don't mind, Ms. Clark, that your son, even as of last week, is standing by the third report. Do you understand that?
No, I don't. Maybe
Obviously,
true.
it calls for speculation, Your Honor.
It doesn't, because he said that he reviewed it and he said that he stood by it.
Remember it.
We'll try to refresh your memory as to this. You could go to the June 16th, just a week ago.
I'm sorry, hang on. Is this the transcript of Mike Haag's interview?
Yeah, that he reviewed, that he testified to, that he reviewed.
I guess I have a concern about your transcript. Mr. Haag's interview didn't take place on June 16th. It took place on June 17th. I'm questioning the validity of your transcript for that reason.
Okay. I'm sure the court will let me proceed and we can deal with that issue afterwards. If he doesn't, I would doubt that the court is going to give that much mind, but I will wait for the court.
I'm trying to verify that this is actually the transcript that they're saying it is, and it's got a different date on it.
Can you explain that, Mr. Spiro?
Not that readily, but I know that it's the same transcript. It's the same transcript that he said that he reviewed. But I can just show him this and ask him if he has any opposition to it. We can deal with the dating of the transcript. The fact that there is some discrepancy if it's one date.
To have him take a look at it, see if he recognizes it.
Yeah, is this a grand jury transcript? I know I'm not supposed to ask questions, but I don't know where this transcript come from myself at this point.
Okay. For now, I just want to ask you if you agree with the conclusion of your son's, which was in the last week, or we'll deal with the date of 16th versus 17th in a minute.
I object to the form of question. What conclusion is he talking about?
That's correct.
Do you agree with the statement that your son makes here?
So many lines. Let's point to what
Okay.
you're asking him to notice.
Sure. So I can go sentence by sentence. The first sentence, do you think there's anything incorrect with?
Yes, a moment ago, what you had bracketed, I don't have any disagreement with.
Okay. And then the second sentence is, it doesn't look like it's from a factory in sum
Right.
and substance. Okay. You agree with that? Okay.
Yeah.
And then it continues. We don't know. Could be. We don't know. Could that be a type of marking that was put there because of somebody working on it prior to the shooting? Couldn't tell you whether it was or wasn't.
From Mike's perspective, he's talking about at the end of August, neither of us knew.
No, this is the transcript that he gave a week ago.
Yes, but he hasn't put in any more time on this whole matter of the marks on the sear.
I don't know what that means, sir, but he testified truthfully, according to him, that as of last week, that was his statement.
So hang on. Mr. Spiro is now testifying. Mr. Spiro is now giving Mr. Haag information that Mr. Haag apparently doesn't have. So I'm a little confused about exactly what we're doing here. Mr. Spiro is asking Mr. Haag whether or not he agrees with an opinion, but I'm not sure that we actually have the opinion yet.
I'm going to go back to the prior sentence. Just ask you if you agree with it. Could that be a type of marking that was put there because of somebody working on it prior to the shooting event? Isn't that possible, sir?
I can read Mike's answer, and I think that's an appropriate answer for back in August of last year.
Okay. Would it have been an appropriate answer last week?
I can't answer for him.
I'm asking you, do you, as you sit here today, dispute that statement that it is possible that it could have been because of somebody working on it prior to the shooting event?
No, I would exclude that as a possibility.
The first time you excluded it of that as a possibility was after Hannah Gutierrez-Reed's trial, after the grand jury in this case, after you gave your first Baldwin PTI, only in the past week. True?
No, I was ruling out the other possibilities as I learned more and more about Ziegler's testing. That was refined in the interview on the 17th.
Did you memorialize that last statement anywhere? Can you point this court or me to anything anywhere other than your most recent PTI and testimony before this court where you in any way walk away from that August 31st, 2023 report?
Judge, I'm going to object. I don't even understand the question that's being asked.
If he doesn't understand it, he can ask me that he doesn't understand it.
I don't understand either. I don't know what you mean by walk away.
Sure. I'll try to clarify. We had talked about maybe 10 minutes ago how you said, so again, until recently, I had to keep it as I did in my report. Until recently. You're now saying that there were these other things happening. And I'm asking you, do you have any document or information that you can show me that suggests before the last week you walked back your August 31st report, that you changed your mind?
I think I've covered that. The history of the gun that's going to have to be shown through other witnesses, but came from Mr. Pieta, Seth Kenny. Those people can establish that gun was just a show gun, was in a display case, finally went to EMF, went directly to Seth Kenny, who turned it around and sent it, put a firing pin in it. There's no opportunity. Again, others are going to have to establish that, but I'm prepared to trust to it. That's important from my standpoint. Secondly, I know what trigger jobs look like. This is not a trigger job. It will take the marks away, not leave gross marks, especially on a diagonal. We're back to, I thought it was pretty simple. Exclusionary process. Beating this gun took on the hammer in a semi-controlled fashion has to be the explanation. Finally, as I said this too, in a way, I don't care. Let's assume those marks are there when Mr. Baldwin is using the gun. They had no effect on its operation.
Anything further you want to add on that answer?
I don't think so.
Okay. At your most recent pre-trial interview in this case, the same date, which was...
Monitor just asked if you can identify what's being put up on the screen. I don't know how the court reporter's handling it, but first of all, you're not even identifying a number, but transcript was from the grand jury, but why don't you make it clearer?
Sure. I'm not used to this Zoom format and I'm terrible at it. So I apologize. I apologize to the court reporter. My question withdrawn. You gave your PTI on June 19th, 2024, 2 days before the hearing before this court, right?
I believe so. We started with.
Okay. And you were asked, can you tell me, other than this most recent meeting, this is very important, sir, so I want to make sure you understand, okay? You were asked, other than the meeting with Mr. Ziegler at the beginning of the week, have you had any other meetings with the state about this third report? Answer, no. Question, just the one with Mr. Ziegler on the 17th? Answer, yes. Do you agree with that?
Yes, as I sit here today, I do.
Your Honor, I have that transcript in front of me, and Mr. Spiro is not reading directly from the transcript.
Okay. I can submit a script into
Look,
evidence.
he is using the opportunity over Zoom When the witness can't see the transcript, he thinks I can't see the transcript. This one I happen to have in front of me. Every time he quotes from it, I can do a word search. I got to exactly where he's talking about. He is not saying all of the words. So if we're going to be quoting from transcripts, my request to the court is that we use every word we quote exactly. Mr. Spiro's not doing that clearly on purpose.
Okay, I'll do it. I'd love to do this one again. I'll do it again.
Let's do it again.
Some of these questions, obviously, when I'm asking you about your testimony, Mr. Haag, you understand I'm asking you generally, did you say something? You do understand that?
No, I think of specifics when it comes to an answer, not general answers.
Okay. Page 13.
Mr. Spiro, if you're going to read rather than
Sure.
asking a general question, then you do need to read.
I will.
Word by word.
So that's fine. Hopefully the court will take note of whether or not my representation was the sum and substance of this question, because there's a page 13, 9, Ms. Clark. Okay, can you tell me about any other meetings that you've had with the state? You say sorry. And she continues, about any other meetings you've had with the state about this third report? Question. Your answer, no. Question. Just the one with Mr. Ziegler on the 17th. Answer, yes. Is that accurate?
I believed it to be correct at the time.
Okay. And,
Correct.
pardon?
And it may still be correct.
Okay. It was only a couple of days ago.
That interview was, but 8 months had passed since the end of August and that pretrial discussion. I did not have a transcript of the previous interview by Ms. Clark or the video of it. And I really should have asked for it and read it to get up to speed because I'd been away from the case for about 8 months.
If you change your opinion on something, you change your report.
It's important or critical. It's just a typographical error. I'm not going to worry about it.
But if it's something important enough to make a report about, your third report, right? You're saying now you're changing your opinion. Do you have any present intention of changing your report now?
No, I do not.
You would agree with me, sir, that you received no questions about the third amended report that we're talking about. No questions in Hannah Gutierrez-Reed's trial. No questions in any grand jury testimony you've given.
Objection question.
Okay, I'll go one at a time. You didn't receive any questions about the third amended report in the Hannah Gutierrez-Reed trial, correct?
I'd have to look at the transcript.
You don't remember as you sit here.
That's right, I do not.
You don't remember ever getting a question about the third amended report in any testimony you've given before any grand jury, correct?
Your Honor, Mr. Haag didn't give any testimony before the grand jury, and Mr. Spiro knows
Mercy,
that.
he answered the question. Okay? Let Mr. Haag answer that question.
I haven't testified in the grand jury matter in this case.
And you never mentioned, you were never questioned about it in any of your previous pretrial interviews, either the one in Hannah Gutierrez-Reed's case, if there was one, or in the one in the Alec Baldwin case until the most recent interview, correct?
No, I think this came up back in April the 29th. That's the one I don't have a copy of and haven't reviewed, or the more recent one by Ms. Clark.
Oh, okay. But I think that you heard Ms. Morrissey, and I'm sure she would stipulate again. We didn't know about the report. We didn't receive the report in April of 2020.
Transcript this weekend, that became apparent. I'd frankly forgotten about it, but it was resolved by the end of that interview in April the 29th.
Okay. It's not resolved, but at this time, I have no further questions for this witness.
Any redirect?
Mr. Haag, just a few questions. Pardon me, hang on just a second. Mr. Haag, based on everything that you've reviewed, is there any reason to believe the gun was not functioning properly prior to October 21st?
No reason to believe it was not working as designed and intended by the manufacturer.
Any reason to believe that the gun wasn't working properly on October 21st?
No,
In fact, haven't you actually watched videos of Mr. Baldwin manipulating the gun on October 21st?
that's my understanding.
Objection leading every question.
2 of the videos show him in the church.
Just a minute.
I'll concede to that. I'll change the form of my question.
Thank
I
you.
apologize.
Thank you. I'll strike that answer until you rephrase.
Okay. Did you review a video on October 21st of Mr. Baldwin in the church with the gun?
A video that was presented as such. I don't remember seeing.
Okay, and you can just say yes or no so we can get through it. Do you recall, did Mr. Baldwin cock the gun?
Yes,
Did the gun appear to be working properly?
Objection. These are all still leading questions, Your Honor.
That is not a leading question to ask if the gun was working properly.
Ask how he thinks the gun was working. Give him an option.
How was the gun working?
In the normal fashion, the hammer stayed back, and it was the evidence gun by the silver nickel-plated hammer in that one church scene, I'll call it.
Mr. Haag, you reviewed all of the documents did you review anything from the FBI?
Yes,
What did you review?
2 reports, one from the explosive section, which probably is,
No, just firearms, just not ammunition, just this gun.
and of course, the final typewritten report concerning the operational condition of the gun, all the notes and attachments and pictures taken by Bryce Ziegler.
Based on your review of the FBI documents, what's your opinion about whether or not the gun was functioning properly when it got to the FBI?
That it was functioning properly.
Mr. Spiro has asked you today, I think he's characterized the gun as being destroyed. Mr. Haag, was the gun destroyed by the accidental discharge testing at the FBI?
No, just 2 parts, actually 3 parts, but 2 important parts.
Those 3 parts, were they retained so that they can be viewed by any defense expert?
Yes,
Sir, in terms of the functionality of the firearm, can you again give the court your opinion with regard to the markings on the sear, how they affect the markings on the working surface of the sear, how they affect the functionality of the firearm?
they were there at the time this gun was being used on the set. It had no effect on the gun. And we know that because we see numerous videos of it being cocked, the hammer holding, some of the scenes for 10 minutes or so while the gun is being pointed in various directions. But most of all, when it gets to the FBI laboratory, those marks were there on the sear. He got a normal trigger pull, it's right in spec with all the other guns. Never had a hammer slip. Fired 12 rounds successfully. Took pictures of the hammer at full cock. In his own initial description, it functioned properly. And he goes through all those tests, some of which I just described.
Do you have an opinion about how the full cock notch of the hammer was shaved off or keened off, I think is a verb that you've used?
Yes, it's a nice, sharp, right angle ledge, a little stick in its original form and all the hammers that we've looked at and photographed, but it got peened a couple of times. There's several pictures of many that Mike has. I think I'm looking at just a number here. I think one of them is 9781, where you can see little chatter or impact marks. And finally, the edge, the once upon a time right angle edge is rounded off. Because of that, the hammer as it exists today, the conclusion of the impacted testing, will not hold a perfectly pristine new trigger in position. It'll slip and fall. But the good news there is it'll slip and fall to the half-cock position, which on this evidence hammer is still intact, still working. That's what I think the second report deals with in the videos.
Do you know whether or not the accidental discharge testing performed at the FBI was done pursuant to their procedures?
Yes, it's part of their conclusion in an SOP, a standard operating procedure, where there's a claim of an accidental discharge.
Sir, in your experience as an expert, not just in this case, but in other cases, do you have any information about whether or not considers the circumstances of the event that they are asked to do testing on a firearm? Does that make sense?
Yes, I understand what you're going. They're of the philosophy, as a number of crime labs, that they don't want to be contaminated by contextual bias. That's the term that's circulating among forensic scientists. Basically, they tend to operate in a vacuum. They've got a protocol, a standard operating procedure that they go through, and these tests would be done in that order. In the final test, if there's an allegation of an accident, such as there was from the very day this incident.
Now, Mr. Haag, I want to ask you a question. You were asked by Ms. Clark on Friday, and you were asked again by Mr. Spiro today about a statement that you made during your April 29th interview, where you indicated you could look at the working surface of the sear and that it looked as expected and normal. Do you recall Mr. Spiro and Ms. Clark asking you about that?
Yes, I do.
And during your interview, were you being questioned about the sear after you put it under the microscope?
I viewed that answer as before it ever got to the microscope. That's how I answered it in that. So unless I misunderstood your question, the markings didn't become of interest until we put it under the high-powered microscope.
When Ms. Clark was questioning you on April 29th during the interview, at the time that you made that statement, do you recall, sir, what the circumstances were of you making that statement? Where were you in the PTI? Can you give it context? What were you talking about?
Yes, she had just shown me a picture, one of Mike's pictures. FSC is his camera code. I think it's 80. I think she identified it as that. That was a starting point that went into those questions and answers. If you go back and find that picture, sear tip is not in it, just the damaged hammer and some other parts, but the actual that's missing is not there. The trigger's there. I said something about the hammer. I think it's a quote. The hammer is the most important part. So I was thinking about the hammer. Then I don't know if she gave me page numbers, but she went on to some other pictures that showed these markings under the microscope and a comparison. Those happened. Some of those pictures were taken at a later time.
Sir, just to be clear, when you made that statement to Ms. Clark, were you talking about what you could see under the microscope or not under the microscope?
No, just
Objection leading question suggests the answer in the context in which she's posing it.
Give a response.
Judge, I disagree that it's leading.
All right, go ahead and answer it. Thank you, overruled.
it was made in the context of just, I'm gesturing now, putting the pieces back together, looking at it edgewise and seeing the fracture match. I could see that the working surface was still flat. It had right angles to it. I turned it toward us, and there's a picture showing that. Or again, we put the two pieces back together. Once again, you can see that the working surface is squared off. So that was my answer. And those views, just with the human eye, other than being broken, of course, it looked normal. It was only until we put it under a high-powered microscope, and it's called oblique lighting, brought lighting in from the side, that it reveals those very rough diagonal marks on the working surface of the evidence sear.
Haag, have you ever had an opportunity in your career to
Evidence sear.
Mr. Haag, have you ever had an opportunity in your career to examine a gun that was damaged by accidental discharge testing by another examiner?
I can't presently think of one, but that's not to exclude them. I tend to move on after a case. I remember certain things like the gun and what it looked like, and maybe if someone got shot, but details like that. I still have a pretty active case though, and I just don't remember anything in the last year or so. But I've worked several thousand cases in the last 50 years.
Mr. Haag, are you aware of how Mr. Baldwin has explained the fact that the gun went off on October 21st, 2021?
The only recollection I presently have is a quote in several of his interviews that I didn't pull the trigger.
Now, understanding that as our landscape, have you seen anything in the FBI report, in the videos, in the forensic testing that you did? Have you seen anything that would support that statement?
No, I have not.
Now, in the previous statements that you gave in the Gutierrez trial, your pretrial interview in Gutierrez, and I believe even your April 29th interview with Ms. Clark, did you have the benefit of the statements of Mr. Pieta?
No.
Did you have the benefit of the statement of anyone from EMF, the import company?
I don't believe so. I'm not sure on that, but I just don't believe so.
Did you have the benefit of Mr. Kinney's statement with regard to what happened to the gun when it was in his possession?
At some point, I had his interview and notes I had taken from it. I just don't remember when, and if I had looked at them before the 29th April interview or before the trial. I have them somewhere, but this file is something like 23 gigabytes at this point.
I heard you mention on cross-examination, you gave an answer and you used a phrase called trigger job. What's a trigger job?
Yes, the tool marks, the fine tool marks that are present on both of these working surfaces, the full cock notch and the sear, are a normal consequence of fine machining. There's a type of stone, finishing stone. It looks like a gray, abrasive, fine powdered material. A trigger job would be, and I'm going to gesture, to work that stone, and you have to be very careful to keep the angle the same so you don't change the angle of the sear, but to get rid of those marks. So you want to make the two surfaces like a mirror. So now they don't grate, that's an exaggeration, but that they don't grate over each other. That's called creep. Shooters do not like that creepy feeling in a trigger. And if you polish it, not roughing it, if you polish it, you can get it down to mirror smoothness without changing the angles. That's a fine trigger job. And now it will not have a gratiness or a creep to it.
What's the purpose of a trigger job? Why would someone do that?
Shooting enthusiasts that are mainly handgun, if we're talking about handguns, target shooters, having creep in there introduces some fine vibration, and that's going to affect accuracy. If you're trying to put 6 bullets in the same bullet hole, you don't need a creepy trigger that you're struggling with. You can smooth it out. So basically, the word is, the gun is, when it goes off, it's a surprise. You didn't realize you had reached the edge of the sear and the full top notch.
And it's your testimony that what you've seen in this gun is not consistent with a trigger job.
That's for sure. Yes, it's the antithesis of a trigger job.
I don't have anything further, Your Honor. Thank you.
Your Honor, I know the court seems to be, even though I have not had the pleasure of appearing before you live yet, Your Honor, soon, hopefully, does not often welcome recross. There's something going on here in this testimony that I am asking for just 1 minute to correct something. And I think that given the seriousness of this hearing and the seriousness of the case, I ought to be given 1 minute.
I'm watching the minute. Go ahead.
This testimony, you recall that when you were with Ms. Clark last week, you didn't remember anything about the April 29th interview that occurred in this case, right?
That's true. I didn't.
And since then, you have reviewed that interview and spoken to the prosecutor, correct?
I asked for a copy of it so I could refresh my memory.
And spoke to the prosecutor, correct?
I don't remember if it was verbal or an email. Please send me a copy of my January 29th testimony and the video.
And Ms. Morrissey played for you some of the PTI videos so that you could see if you could hear Ms. Clark. Do you remember that?
No, I don't.
You don't remember her doing that?
I don't remember her doing that.
And do you remember having substantive any communications with the prosecutors since we left court on Friday?
Well, yes, of course, to say, please send me this transcript and the video. And then about the time, that's about it.
No other communications about what questions you might be asked or things to clarify on your examination, sir?
No.
And did you ever inform your son of your reversal of conclusions after the meeting with Mr. Ziegler?
No.
And
All right, thank you.
thank you.
All right, so everyone rests. So let's go with argument.
Your Honor, just for a moment, first of all, can the witness be excused?
Yes.
Come to find the leave button. Where is it?
I can't help you with that, sir.
Okay.
All right, so Ms. Morrissey,
Just
go ahead.
Up here in the
You-
corner.
Well, Your Honor, I need to
What?
make a record after the witness leaves.
Okay, go ahead.
So, and I understand the court's time is precious, but I have to make records. Okay. The court should know that we have filed a series of Brady motions and a supplement to the Trimbetta motion. I don't know if the court has seen it, but they are hitting or on the docket. The court also needs to be aware that we've made discovery demands, many discovery demands for many emails and other things. And when he got them and when he learned them, they have not been provided to the defense to date. I was going to move to preclude his testimony entirely, and we have a very serious issue of him being provided information on cross-examination. That issue is not waived. In addition, the defense would seek to call briefly Mike Haag, who will stand by the August report. So the defense is not resting without that evidence before this court and at this hearing.
Well,
He's in the waiting.
I am not going to entertain Mr. Haag. You can certainly bring those up in your motions that you've made before the court. This is a motion to dismiss the indictment based upon your claim of the destruction of evidence. I want to hear argument on that. Go ahead.
Understood.
Mr. Morrissey.
Understood. So we will just preserve the ability, hopefully post argument, to submit what we need to submit for Mr. Haag if the court does not accept the transcript that I showed. Just a last point, just to clarify.
I'm not clear on what you're saying.
Well, I'll take them in less significant to more significant order. The transcript that I said 16th versus 17th, that debate that occurred at the beginning, The person giving the examination said 16th when it was really the 17th. They just misspoke. So then throughout it, it says 16th. It is
All right,
obviously
I don't want you to submit that again. I will use that exhibit that we used here. I don't know what
Thank you.
number it is, but it's the transcript of the grand jury, January 16th grand jury.
It's the pretrial interview from June 17th of this year.
Oh, I
Mm,
apologize. Pre-trial
no,
interview of Mr. Haag on June 17th. Okay,
Correct. Thank you, Your
all
Honor.
right, all right, argument.
Your Honor, this is John Bash. I'm going to be
You know
delivering
what? There's
argument.
only one person that gets to argue this from this law firm. What are you going to be doing? The argument?
Yes, Your Honor, and I was just wondering if we would go first since it's our motion.
Well, go ahead. That's not how the evidence played out, but
Okay.
any objection, Ms. Morrissey?
I don't have any objection. I will say Ms. Johnson will be arguing on behalf of the state. If Mr. Bash wants to argue, God, let's
right,
just
okay.
get moving.
All right, okay, fine. Go ahead.
Thank you, Your Honor. And with the court's leave, Ms. Clark is going to put up a PowerPoint as I talk. It just shows how the evidence over the last 2 days marries up with the legal standards in this case. We can go to the next slide. So, Your Honor, we're here on a motion to dismiss the charges or in the alternative to fashion lesser remedies such as suppression and an instruction to the jury for the state's intentional destruction of evidence in this case. Now, there's 3 legal standards, as the court knows, that govern here. One is the federal Trombetta standard. That was an opinion by Justice Thurgood Marshall for the court. The second is the Youngblood standard, also from the U.S. Supreme Court. And the third is New Mexico law, which has its own set of standards about this issue, and which in some respects is more favorable to defendants, as New Mexico law often is. Sarah, we can go forward. So I'll just say, Your Honor, by way of introduction, I've reviewed a lot of the case law in this area since we've had this issue, federal, state. This is among the most egregious constellation of facts I've ever seen. I was at the U.S. Department of Justice for 7 years. I never saw anything like this. And just to give an overview of the facts in play here. One, everybody agrees the gun is central to the government's theory of guilt. They believe Mr. Baldwin pulled the trigger. They believe, contrary to our argument the other day, that establishes his guilt. The gun is central. They're relying on scientific or technical analysis of the gun to establish his guilt. It's central. I don't think they're going to dispute that. Second, another thing they're not going to dispute. The state knew that Mr. Baldwin had said he did not pull the trigger at the time they ordered the destructive testing. Corporal Hancock admitted she was aware of his interview on national television stating that he did not pull the trigger months before they ordered destructive testing. I believe Mr. Ziegler testified that he didn't know much about the case, but the one thing he did know is that Mr. Baldwin had said he did not pull the trigger. The state knew that before they destroyed the evidence. Third, the state knew that other witnesses had said the gun just went off, and we'll talk about that, but we've submitted that as evidence in this case. I believe it's Exhibit K to this motion. So multiple other witnesses said the gun went off. The state knew that the FBI testing would destroy the gun. Again, there's not going to be a dispute about this factually. There is an email in which Corporal Hancock's on it, FBI Special Agent Cortez is on it, and Mr. Ziegler's on it. And it says, we're tracking that this will alter the firearm, the key evidence in the case. And no one reached out to the defense, and no one said, maybe we should photograph the parts so that's available to the defense as they try to make their case. The state has given no reason in their briefing or in any of what you heard over the last 2 days why they did not seek at least to have those internal components photographed before they took a mallet to the key evidence and broke it. That testing was pointless. You heard today their own expert, Mr. Haag, say there was no point. It was totally unnecessary. It makes no sense given the facts of this case because no one alleges a blunt force object hit the gun. It had nothing to do with anything. And worse still, Your Honor, they failed to do the test that actually might have made sense, the push-off test, where you take your thumb and you apply pressure in different ways to the spur of the hammer. And now we can never do that. We can never do it because they broke the hammer. And then the stuff we've heard a lot of today, that they had a report that said there was pre-existing modifications. They didn't disclose it for 9 months. They never even disclosed it to Ms. Gutierrez-Reed. They had their expert testify that he saw no other evidence of modifications when he had written a report and submitted it to the prosecution saying he did see other evidence of modifications. This is some of the most egregious conduct with respect to the destruction of evidence you will find in a reported decision. Sarah, can we go to the next? And just by way of overview, and then I'll get into the legal standards and the evidence. The state's arguments, Your Honor, in many respects, totally missed the point here. This hearing was not about whether Mr. Haag has a persuasive opinion. It's not about whether Mr. Ziegler has a persuasive opinion. It's whether the state was justified in depriving the defense of the opportunity to examine the firearm with its own experts in the original state. And we can never do that now. They've broken the hammer off. The full notch of the hammer off. We're never going to know what that looks like. So here's just one example. The state says, per Mr. Haag, that, well, the FBI testing broke off the full cock notch. That's why there's no notch. Okay, let's assume that's true. But we will never be able to assess what the full cock notch looked like in its original state. Did it have those unexplained markings on it? Was it smoothed a little bit in a way that it might not catch every single time on this year? We have no idea. And in fact, you just heard Mr. Haag say, well, we have all the parts. We don't. We don't have all the parts. We don't have the full cock notch. If you look, I think it's exhibit L, maybe, Sarah, or O. There's a picture of the box that has all the pieces that were broken, including little parts that were broken off, like the little sear. There is no full cock notch in there. The part of that was broken off is nowhere to be found. Maybe it was disintegrated. I don't know. With the state's testing, we will never be able to analyze that. That is the idea of criminal prosecution is, in a sense, the cards are stacked against the state. They have to prove beyond a reasonable doubt. But now they've stacked it against the defendant. I mean, they got to do all their own analysis of the gun, and we never got to do it, and we'll never get to do it. And this is just a really important point in light of what we just heard. Mr. Haag has no idea what that full cock notch looked like in the original state. He doesn't. He can make an opinion that it was fully broken off or sheared off because of the mallet. He has no idea what it looked like, and he can't. No one knows because no one bothered to check, and no one cared about the rights of the defendant to have an opportunity to make a case. Next slide, please, Sarah. Another way the state's argument misses the point, Your Honor, almost their lead argument in the presentation the other day was, well, the gun was working fine in the sense that it fired, on the days leading up. But we all know that when machines don't work correctly, they're not working correctly every single time. I mean, I had a key that one out every 10 times it wouldn't turn my lock, and the other 9 times it worked fine. I mean, sometimes these things happen randomly. It's hit at a certain angle. It's used at a certain angle. I mean, that proves nothing. And the idea that they can just destroy the evidence and say, well, it was working fine before, so it must be okay, that is not what due process requires. Next, Sarah, please. So, and this really stuck in my craw, Your Honor. And Mr. Ziegler seems like a good guy, but I mean, he did not receive the right training in the law if this is what he thinks. He said repeatedly, I had no reason to disassemble it. I had no reason. He means he had no reason for what he wanted to do. But he did have a reason to do that. The reason is to preserve evidence for a criminal defendant. And that is an absolute obligation under Brady and Trombetta and Youngblood. The government is supposed to preserve evidence so the defendant can take a crack at it. And so the idea that none of these people, the prosecutors, there's a typo there, but it's supposed to be SFSO or the FBI, none of them cared about their obligations to criminal defendant. Didn't even cross their mind. Didn't cross Corporal Hancock's mind. It didn't cross the prosecutor's mind, and it didn't cross Mr. Ziegler's mind that, hey, wait a minute, it's more than our investigation here. We might charge someone and attempt to imprison them, and they need a fair opportunity to look at this evidence. So let's go, Sarah. Okay, so there's 3 standards here. We'll zoom through this part pretty quickly, Your Honor, because I know you know this. So the Trombetta standard, that was that Thurgood Marshall opinion. The evidence needs to be apparently exculpatory, and there has to be no other comparative evidence. So it's in a sense like materiality and prejudice. The evidence mattered, and you can't get it another way. Let's go to the next one. Then there's this Youngblood standard that comes along. And what the Supreme Court said in Youngblood is, even if you can't show it's apparently exculpatory, and in a lot of cases, you're not going to be able to, because that's the whole problem. They destroyed it before you could look at it. Even if you can't show that it's apparently exculpatory, if you just show it's potentially useful and the government acted in bad faith, you're also entitled to relief. And what the Supreme Court said in Youngblood is that potentially useful, Your Honor, just means indeterminate. They could have run tests on it, and maybe it would have showed something. That's all that means. That's a low bar. And a lot of the cases that have granted relief, it's been under this test. Let's go to the next slide. And so this last one is New Mexico law, Your Honor. And as I said, I read it as a little more protective of defendants' rights. And my understanding is that's pretty common across areas of criminal procedure in this state. And so the way we understand the test is that it requires either bad faith or materiality and prejudice. And the reason we read it that way, the font's a little small here, but there's this quote from the leading Supreme Court case on this, Chouinard, I hope I'm saying it right, where the state shows it did not act in bad faith, the defendant must show materiality and prejudice. So we read that as an either or, but even if the court didn't read it that way, I think it's indisputable that at least a showing of bad faith would reduce the showing you need to make on the other factors. So let's go to the next one. Okay, so this is really important. We think that bad faith is one of the keys here, because if you agree on bad faith here, this is pretty straightforward. As I said, we read New Mexico law to mean as if you have bad faith, and as long as the gun is determinative of guilt, which I don't think can be disputed insofar as the state's legal theory depends on whether he pulled the trigger, then we're entitled to relief. That's how we read Chouinard. And again, even if it's a sliding scale, it's going to be pretty likely we're entitled to relief if we establish bad faith. The second thing is under Youngblood, again, you only need potentially useful, which just means indeterminate, and bad faith. So again, if we show bad faith, I think we're almost certainly entitled to relief at that point. So let's talk about bad faith. So really important, Your Honor, bad faith does not mean maliciousness in this context. It does not mean Ms. Morrissey and company were out to imprison an innocent person or anything like that. It doesn't mean an ethical violation. What it does mean is that, and this is right from Youngblood, U.S. Supreme Court, the police themselves, by their conduct, indicated that the evidence could form a basis for exonerating the defendant before they destroyed it. So it's basically looking at, well, did the police think of this as potentially exculpatory evidence and then just went ahead and destroyed it? And this is the other quote from Youngblood, and it's cited in a lot of the cases in this area. The presence or absence of bad faith by the police for purposes of the due process clause must necessarily turn on the police's knowledge of the exculpatory value of the evidence at the time it was lost or destroyed. So no one's accusing anybody of ethical misconduct on this one. That's at least not necessary for the legal test. What it means is that they had an awareness that this was potentially exculpatory. And instead of stopping and saying, well, what do we need to do here? Do we need to document this? Do we need to preserve this? They just went ahead and destroyed it. Let's go to the next one. So we're just trying to give you some of the quotes from the hearing, just because that's what this was all about. It's clear, Your Honor, the entire purpose of the testing here was to either verify or dispel Mr. Baldwin's exculpatory statement. That was why they did it. There's no dispute about this. I mean, they elicited this on direct. Ms. Morrissey asked, and what was the reason that you proceeded with the testing anyway? And this is at the trial, I should say, of Ms. Gutierrez-Reed. We proceeded with testing because Mr. Baldwin had made statements that he didn't pull the trigger. And I'm going to throw in some ellipses, but the statement's there for everybody. So we needed to figure out how to disprove that theory or that statement. I mean, could there be a more textbook case of the Youngblood standard? They were doing this in order to disprove an exculpatory statement. That was the whole purpose of this. They clearly knew that the exculpatory nature, that the firearm had potential exculpatory value. They clearly knew that. And then they were told, and we're going to destroy it. And they didn't say, go make a picture of it. Go photograph it so it's there for the defense. And then Ms. Hancock, Corporal Hancock, just Friday testified to the same thing. She said, we were testing the theory due to the statement he made that he did not pull the trigger. So clearly they understood the exculpatory value. They were trying to disprove it. That's why they did this. Let's go to the next slide. So again here, and I won't belabor it too much, Corporal Hancock said on Friday, I think this was Mr. Spiro asking, you were not certain at the time of the destructive testing that he had pulled the trigger. That is correct. It was quite possible in your mind that the gun had just gone off and that he hadn't pulled the trigger. That was the theory we were testing. They understood that this was potentially exculpatory evidence and they destroyed it anyway. Next slide. Okay, this is an easy one. The firearm is clearly central to the government's theory of guilt. If you read virtually any brief they file in this case, they say he pulled the trigger. And of course, Corporal Hancock accurately said yes when asked, you knew that the gun was an important piece of evidence. So unquestionably central to the case. Okay, did they have knowledge that Mr. Baldwin had said he didn't pull the trigger? Well, we just saw it. That's why they were testing it. Numerous legal decisions have pointed to the defendant's exculpatory statements. So I'll just give one, and if I'd urge the court to closely look at any decision cited by the briefs, it's actually the CDNY District Court decision by Judge Deary, who's, as I'm sure you know, one of the most respected federal judges in the country. And it's a Soriano case. And in that case, a woman who was found with drugs in her bag at the airport claimed she was just a food courier. But the government had destroyed all of the food items and food related stuff in the bags and I believe hadn't photographed them. And Judge Deary said, well, you just destroyed the evidence that could have allowed her to raise her exculpatory theory. You can't do that. And you knew that she was telling you her theory. In her interview, she said, I'm just a lowly food courier. I didn't know anything about the drugs. You were on notice of her theory and you destroyed it and you didn't take pictures. And you should have at least taken pictures, because then defense counsel could have showed that to the jury and said, see, her excuse makes sense. She had a bunch of food stuff in there and just a little bit of drugs. And at the hearing on Friday, Corporal Hancock, again, why did you approve the test? Well, during the interview, I think she's referring to the George Stephanopoulos interview, he had made a statement that he didn't pull the trigger on that firearm, which is why we proceeded with the test. She knew about the statements. It's not only she knew about them, that was the reason they were testing them, because he made exculpatory statements. Let's go to the next one. Okay, and put aside Mr. Baldwin for a moment. They also had knowledge that other witnesses had said the firearm went off. Ross said in the commotion of making the movie, the gun went off. The court has all these. I believe they're in Exhibit K, or it looks like Exhibit N. The court has all of these. Multiple witnesses said it went off. I think I heard Corporal Hancock testify on Friday. There was some kind of common phrase like went off. I don't know if they're going to get up and say, well, went off could mean pulled the trigger or not. But you'd think if you were confronted with what they would assert are ambiguous statements, you would say, wait a minute, let's go talk to people and see if there's some legs to this idea that it went off before we destroy the gun, so that the defense can never prove up that theory. They didn't do that, as far as we know. And then here's just a little bit of the colloquy with Mr. Spiro and Corporal Hancock on Friday. Hannah Gutierrez-Reed told you that if you touch the trigger, it will just send the hammer down. She told you that, right? Yes. She had also told you that she had trouble loading a firearm on the day of the incident, right? Yes, she did state that. The state had they had red lights going off saying this gun might have been defective. This gun might have some issue where it goes off without the pull of the trigger. They knew that because that's why they ordered the testing, but they didn't preserve it for the defense. Next slide, please. So this really cannot be disputed either. The state knew the testing would permanently alter the firearm. There's an email. They can't get around the email. The email is from the FBI special agent in New Mexico to Mr. Ziegler, CCing Corporal Hancock. We're tracking that this will alter the firearm, and it will not longer, I think it means no longer, be in the same physical condition that it was seized in. Now, at the hearing on Friday, they tried to get into will or may. I don't think that really matters legally. I mean, if there's a non-trivial chance it's going to destroy it, I don't think that would make any difference in the legal test. But at any rate, they said will. I heard Corporal Hancock get into something on alter versus destroy versus damage. I don't think any of that has any legal consequence. You can't make it so that the key evidence in the case is not accessible to the defense when they're trying to establish innocence or show reasonable doubt. Next, please, Sarah. Okay, this to me is key, Your Honor. There's been a lot of briefing. You've now sat through a lot of testimony on this. They have never given a single reason why they did not disassemble the firearm and take pictures of the internal components, knowing the risk that they would be destroyed. They haven't come up with anything. We'll talk a little bit about their argument about standard operating protocol, because that's a complete red herring. But there is no substantive reason why they didn't do that. If you look at the pretrial interview of Michael Haag, it's quoted there on the left, although our font is starting to get really small here. They say they always disassemble the firearm first. So, I mean, they know what they're doing. And they always disassemble it first. If you look on the right, this is from Friday with Corporal Hancock. You did not ask the FBI to disassemble the firearm to take pictures of it. Do you? I think it probably mean, did you? I don't know their process or how they run their testing, so I don't believe it was specifically requested from us. And she didn't ask to videotape it either. It's not about the FBI's process. It's about an investigation by New Mexico law enforcement and New Mexico prosecutors that is there to both find the truth and to protect the rights of the defendant. And they didn't do that. They didn't think about it. They knew it would be destroyed, and they did nothing to preserve the evidence for the defendant. Two more quotes on this. Again, Ziegler, this is from Mr. Ziegler. This is from his testimony on Friday. He didn't disassemble it. That's correct. I did not do that. Okay, he didn't do it. And this is really key, Your Honor. I think Mr. Spiro asked him, and you don't know if the gun had any internal damage before you did the test, correct? He's honest. He's honest. I can't verify that. I can just tell you that it had no effect on the function. That's his claim. And you don't know if the gun had been modified before you ran that test, correct? That's true. I do not. And the reason is he didn't bother to disassemble it and document what it looked like. He has no idea if that full cock notch had modifications, smoothings, scratchings, whatever, that could have caused it 1 out of 10 times or 1 out of 20 times not to catch on the sear and release that hammer. He has no idea. Next, please. Okay, and this is really egregious, Your Honor. Their own experts, the Haags, have admitted that the test they ran was totally pointless. You heard it again today. I think it was maybe Mr. Spiro's first question this morning or this afternoon. You have the quotes there from Corporal Hancock. Mr. Spiro asked her, did you do any research on this testing? Well, I was aware that it would damage the firearm. Did you look into other options? No. Did you confer with any experts? No. Is there anything else that we haven't talked about that you did to help answer the question of whether or not to do the test? No. They didn't take any time to say, does this test make sense? And I know they're going to come back and say, well, the FBI said it was the right test. But as you know from hearing Mr. Ziegler, he had no clue what the circumstances of the incident was. He didn't know it wasn't hit with a blunt force object. He didn't know it wasn't dropped. Only thing he knew was that Mr. Baldwin said he didn't pull the trigger. He didn't know anything else. So they can't blame it on the FBI. They didn't tell them the facts. Next, please, Sarah. Okay, and this is again from Corporal Hancock's testimony on Friday. And I'm asking you at that point, did you explain in any way, shape, or form the circumstances surrounding either the pulling of the, I think you meant trigger, and what happened, or any of the circumstances that led to the incident? And I'm skipping over a few words there, but you can read it. There was actually very limited information given to them, and Mr. Ziegler confirmed that. So this isn't standard operating procedure. This isn't just what happens. They didn't tell Mr. Ziegler anything about the facts, so he had no idea whether he should be doing the mallet test. And the Haags have now repeatedly confirmed that the test was pointless. So, I mean, I cannot imagine when I used to run a prosecutor's office right across the border, if my AUSAs came to me and said, we have an accidental discharge claim, we destroyed the gun, okay, did you document it? No. What was the point of the test? It was actually pointless. Did you do the test you should have done? No. I mean, it's outrageous. And so here's just more on the pointless mallet test. This is from Ziegler. You had no reason to believe that the prop gun on the movie set had been hit with a hammer. No, sir. And you also didn't believe that the gun had been dropped and fired. I had no background knowledge. The reason is not because Mr. Ziegler did anything wrong necessarily. It's because the prosecutors and the sheriff's office in this case did not tell him the context before he broke the gun. And then here's just what I was saying. Mr. Haag, this is back, actually, this is some of his testimony from Friday. You would agree that the testing that Mr. Ziegler did was unnecessary. Yes, I would, and I do. So, and I just note, right at the beginning today, Mr. Haag again agreed with this. The testing was unnecessary. Next, please, Sarah. And this is what I was just referring to. There was actually a test that might have made sense, and Mr. Haag has said that it would have made sense, but they didn't run it. They didn't do the push-off test. That's putting your thumb behind the hammer. That might have simulated, okay, you know, if Mr. Baldwin's thumb was on the hammer and something happened, he put pressure on it a certain way, could this gun have gone off? They didn't do it, and we can never do it now because they destroyed the full cock notch, and so you can never do that test. The defense can never do it. We can never try to establish reasonable doubt by doing an appropriate test, one that I think Mr. Haag called useful, because they ran a test that Mr. Haag admits was pointless. Next, please. And then this last thing. And this is a aspect of this case, Your Honor, that, I haven't actually seen this in the case law. It's so egregious. It's essentially a Brady type spin on the Trombetta problem. So we've been over this a lot, so I'm not going to recap everything. But the Haags wrote a third report in August 31st. They said in that third report, there are unexplained modifications on this firearm, on the sear. We have no idea who did this. It likely was not the FBI. They said that. They submitted it to prosecutors like they were supposed to do. They were being careful. We didn't get this report for 9 or 10 months. I don't know if it was intentional or not. Ms. Morrissey said it was an oversight. We didn't get this report until it came out in a pretrial interview that it existed. Ms. Gutierrez-Reed never got the report. Her lawyer never got that report. The state stipulated to that earlier today. And then here's what we were, let's go back, Sarah. Here's what we were talking about earlier. People wanted the transcript cite. This is from Ms. Gutierrez-Reed's trial. Mr. Bowles, who, as you know, was her lawyer. Okay, sir. So other than the FBI testing, breaking those components, you didn't see any other evidence of modification or damage. I did not. Your Honor, at that time, way before these recent meetings with Ziegler where they changed, or at least where Luke Haag changed his conclusions, he had submitted a report to the prosecution saying there are unexplained modifications that were likely not caused by the FBI. And then he testified in open court, there are no unexplained modifications. It does not get starker than that. Let's go to the next slide, Sarah. Now, I listened today. We kind of worked up this slide really quickly as we were listening today. And I didn't hear any plausible explanation for the discrepancy between this third report back in August of 2023 and that categorical denial at Ms. Gutierrez-Reed's trial. I think I heard him agree at one point that it was only recently that he rejected the conclusions in that report. I believe that was in connection with that recent meeting or Zoom call with Mr. Ziegler. And he said, I think I heard him say that he had no other meetings with the state about the report beyond that recent meeting. This is, if you needed any more evidence of bad faith, not only did they not allow us to test the gun in the original state, when their own experts found out that, wait, there were other modifications here, they didn't disclose it to us. They didn't disclose it to Ms. Gutierrez-Reed. They weren't going to disclose it until we found out about it. And then they got their experts to meet and come up with some kind of an explanation. That is extraordinary bad faith. Can we go to the next slide, please? Okay, I won't go over this whole timeline because we've laid it out in the briefing, but this just shows, we can go back for a second, but this just shows the egregiousness of what happened. This report was drafted in August of 23. We did all the normal requests for discovery. We didn't even find out about the second report until an interview. And then we find out about the third report on May 21st, a month ago, when this trial is set for July. It is just extremely unfair that the state could use this technical analysis in a prosecution, given this record of what happened here. Next, please. Okay, so I'll go over the state's excuses here. And by the way, although I'm putting this all under the auspices of bad faith, a lot of this factual material is relevant to the other factors, and that's why I'm going to zip through those when we get to those, because a lot of it's the same stuff. So I think their number one response, Your Honor, is going to be, well, this was just the FBI's standard operating procedure. You heard that elicited a lot, and it's true. Some of the cases say, not absolutely, but there's kind of a presumption of good faith if they're just doing standard operating procedures. That's totally inapplicable here. One, that exception, and there's this 10th Circuit case in Bowl that the parties talk about, that exception, Your Honor, is about like disposal policies. So for example, the government doesn't want to have a huge building filled with cocaine from every case ever. So they have disposal policies about cocaine. And usually it's not reasonably disputed that the substance was cocaine once there's been a test by a reputable machine. I have never heard of a policy that says we destroy the gun in an accidental discharge case. There is no policy like that. And there is no way that the government can circumvent Trombetta and New Mexico law and Youngblood by saying, you know what, that's just our policy. We just destroy the evidence. That's our policy. No, we don't document it. We just destroy it. That is not what the Supreme Court has meant by disposal policy, by standard operating procedure. They mean things that really evince that nobody was thinking about the exculpatory value. It's just we can't store mountains of cocaine in the storage facility, so we have to have some way to dispose of it. Second, and this is maybe the key here, Bold itself, which is again the key 10th Circuit case, says provided there's adequate documentation. So you got to adequately document the thing you're destroying. And so when it's cocaine, you document all your tests, how you did it, maybe you even take pictures of it. So you can't, it looks like cocaine. The defendant will have access to all of that. There was no adequate documentation here. That's the whole problem. They didn't take it apart. They didn't take pictures of it. And then finally, they keep trying to blame this on the FBI. The FBI had no clue what the circumstances of this were, nothing. All the information Mr. Ziegler got was from TV. And all he knew is Mr. Baldwin said he didn't pull the trigger. They didn't tell them anything. The FBI does not have a standard operating procedure that says, in an accidental discharge case like this, we always run the mallet test. He's just saying there is a way to run the mallet test that we do. He's not saying the mallet test is appropriate in every case. And their own expert has now conceded it was not appropriate. And if you just see his testimony Friday, he said we asked him, you wouldn't have recommended the test I think we were saying if you knew what you knew now. He said that was not my decision. So blaming it on the FBI is not correct. They were not given the context of what happened here. Next, please. Okay, I don't know if the state's going to say this was just negligence because that's an exception. That's not enough in the case law. I haven't really heard them elicit that, but it wasn't negligence. This was knowingly destroying the firearm. And it's kind of ironic in a case conceitedly about an accident. The state could somehow get away with intentionally destroying the key evidence and depriving the defense of that evidence. Next, please, sir. Okay, and so this is something that's come out in the testimony, Your Honor, and it really cannot be credited. The state keeps saying we were not on notice that he did not that there was a defect in the gun, or that he was claiming there was a defect in the gun. But he's an actor. There's no question he was saying he did not pull the trigger and the gun went off. Clearly, any common sense understanding of that is that there was a defect in the gun that caused it to go off. Something went wrong. I mean, I'm not a car expert. If I tell the mechanic I push down on the brake and it did not break, I don't have to tell the mechanic, and I think that's because there's some problem with the brake fluid. I mean, you're obviously conveying that there is a defect when you say the gun went off without me pulling the trigger. So, I mean, it's almost hard to believe they keep relying on, well, he didn't tell us there was a defect. If he told us that, we would have done something different. He said the gun didn't go off. He said the gun went off without him pulling the trigger. Obviously, he was conveying to any common sense person that there was some problem with the gun. Next, please. Okay, and then the last thing I heard them say, I think they asked a question like, well, did defense counsel ever notify you they don't want us to destroy the gun? Your Honor, defense counsel had no clue the state was thinking of destroying the key evidence in the case. There's nothing that would lead them to understand that a case all about a gun, the state would destroy the gun, not document it, run a pointless test without notifying defense counsel. The reality is the state didn't care about the defendant's rights, didn't care about Ms. Gutierrez's Reed's rights either, and didn't bother to notify any defense counsel of what they were about to do. And the proof of that is that they then went on not to notify defense counsel about the Haag's report saying there were pre-existing unexplained modifications. This is a pattern. This isn't something that just happened once, a mistake. This is a pattern. They did not want the defense to be able to make a case from the physical evidence of the gun. And in multiple respects, they denied the defense that opportunity. Next, please. Okay, so that's bad faith. And as I said, I'm not going to go extensively on these other factors because it's a lot of the same facts go to all these issues. But there's really overwhelming evidence, Your Honor, that the firearm was apparently exculpatory, meaning there was reason to believe it was exculpatory at the time it was destroyed. As I said, it's central to the case. Both Mr. Baldwin and other witnesses told investigators that it just went off. Witnesses, I think we mean Ms. Gutierrez Reed, said it could go off if you just touch the trigger. Mr. Ziegler, by the way, said Friday that the full cock notch was flatter than the other two notches. So there was visual reason to think there might be something going on here. Next, please. Okay, so this all comes from today, Your Honor. So we've already talked about the third Haag report said there were unexplained modifications. And as you heard Ms. Morrissey elicit on redirect, their explanation for that is, well, okay, even if there were unexplained modifications, and even if the FBI didn't do it as they originally thought, and as I think Mike Haag still thinks, those modifications couldn't have caused the firearm to go off. 2 points on that, Your Honor. One, we can never test that because we don't have the full cock notch. And again, this hearing's about Why do we never get to make our own case and test this evidence? It's not about which expert is the most persuasive. Two, Mr. Haag misunderstands, he's a very smart guy on the technical stuff, but he misunderstands the potential relevance of those modifications. It's not just, Your Honor, that maybe the modifications could have caused the firearm to go off without the pull of the trigger. It's also that they indicate someone else was monkeying around with this firearm. And remember, we don't have the full cock notch. We have no idea if the same person who put those modifications into the sear also did something on the full cock notch. The relevance of those modifications is not just what they could have enabled to have happen. It's what they indicate about the fact that someone else we don't know was monkeying around with the internal workings of this firearm before October 21st and before it got to the FBI. They missed the relevance of that, and his explanation doesn't account for that. He admitted, I thought this was very telling, that he's never seen damage like that on the sear of another gun. And this is like the most experienced guy you can have. I mean, 57 years, he's never seen damage like that. And then this is, very telling. Ms. Morrissey dismissed the charges, and I guess she can account for exactly why she did this, but my understanding is that she dismissed the charges originally in the first indictment because she felt there was a need to investigate the condition and the possible modification of the firearm. So again, the standard here is not, is this clearly exculpatory? It's whether it was apparently exculpatory. And the prosecutors obviously thought at the time they dismissed the first indictment that there was an issue there. They thought they showed that by their own actions. Next, Sarah, please. And this is just a legal argument the state makes. It's totally wrong. They say apparently exculpatory means actually exculpatory. There's this one part of their brief, Your Honor, where they're quoting a bunch of stuff, and then they get to the last sentence of that paragraph. I wish I had the page cite on me, but I don't. It's not a quote anymore. It's just like their words, and they say actually exculpatory, and they cite Bohl, that 10th Circuit decision. Well, I mean, I looked at the page. It does not say actually exculpatory, and that makes no sense at all. I mean, essentially what they're saying is that you have to have objective evidence proving the destroyed evidence was exculpatory. Well, that test would be met in literally 0 cases. And the reason it would be met in 0 cases, Your Honor, is remember the second requirement under Trombetta. You can't have comparative evidence that you can use. Well, guess what? If you had objective evidence that the destroyed thing was exculpatory, that means you would have comparative evidence and you could just use that. So literally you could never win the test if it was, you have to have some kind of objective evidence establishing that it's actually exculpatory. What you need is evidence showing it was apparently exculpatory at the time they destroyed it. And we have that in spades. Next, Sarah, please. Okay, real briefly on this, because I don't really hear the state to contest this vigorously. We easily meet the second Trombetta factor, which is that we don't have any substitute evidence we can use. And the simple reason is that the typical substitute evidence you have is you can get someone on the stand that knows the thing, knows what it looked like before it was destroyed, knows the key fact, and ask them about it. We can't do that because nobody in the state and nobody in the FBI bothered to disassemble the firearm and look at it. They certainly didn't take pictures, but they didn't even, you heard Mr. Ziegler say, he didn't bother. He didn't think he needed to. So we have literally nobody we can ask about what did those parts look like? Was the full cock notch and the way it interacted with the sear, was that a problem? What did the sear look like? What did other internal parts that were broken look like? So we have nobody we can ask about that. So there is no comparative evidence in this case. And it's a lot like this Ninth Circuit Zaragoza case. There, a woman claimed she had been forced to carry drugs across the border under duress. And she said, just look at the video of me crossing. You'll see I'm under duress. And they destroyed the video. And the government said, well, you can just call some border agent to say what she was doing. But there were no border agents who had seen her. Well, it's the same thing here. There's nobody that disassembled this firearm and closely examined the internal parts. And so there is nobody to call. Next, please. So that's Trombetta. Just quickly on the alternative ground under New Mexico law. So if we don't establish bad faith, or if you think we need bad faith plus, all the reasons we've said, this was material and prejudicial. There's reason to believe further testing would have showed that this firearm was capable of discharging without the pull of a trigger. We were denied that opportunity. The state repeatedly took steps to deny us that opportunity. And the gun is central to their theory of guilt and essential to their theory of guilt. Next, please. Just real quick here, Mr. Ziegler's testimony from Friday shows how material it is. Mr. Spiro was asking him about certain scenarios if it could accidentally discharge. And one of the things he asked him was, what about if the notches were worn? That is a possibility. Remember, we don't have the full cock notch. They destroyed it. We can never get it back. And then he noted that the full cock notch in his quick view looked flatter. But of course, he didn't closely examine it as far as we know. Next, please. And so this is our last slide, Your Honor. Although I want to make one point on the merits before I get to the remedy that I just overlooked in our presentation. One of the things Mr. Haag has said is that, well, we know from our testing that the FBI testing must have destroyed the full cock notch. And the reason he says that is because obviously at the beginning of the FBI testing, it was staying in the full cock position. And by the time it got to the Haags, it wasn't. And so he's drawing the inference, well, it must have been the testing that destroyed it. Here's what's important to understand about that, Your Honor. He cannot say that that means the full cock notch was non-defective before the FBI testing. He can say that the FBI testing like fully broke it, and so it would never catch. But he has no idea whether there was some minute defects in that, some issue in the way it interacted with the sear that could cause it to malfunction 1 out of 20 times, 1 out of 10 times. He has no idea. He was never given the opportunity to do that. So he cannot validly represent that he knows that all damage was done by the FBI testing, because it's impossible for him to know that. So lastly, remedy, Your Honor. In Trumbetta, Justice Thurgood Marshall, who was writing for the Supreme Court, said the remedy is dismissal or suppression. We have the cite there. In this case, we think the remedy should be dismissal because Mr. Baldwin really can't put on an affirmative case for acquittal to the full extent that a criminal defendant is entitled to do without his own ability to test the gun. It's an accidental discharge case. This is not a case where the gun is tangential. The gun is core. And the prosecution denied the criminal defendant the opportunity to see it, to test it. It's outrageous, and it requires dismissal in this case. In the alternative, Your Honor, we think an imperfect, but certainly better than nothing, remedy would be to suppress all evidence and argument by the state that Mr. Baldwin pulled the trigger, and then give a corresponding instruction that he did not. Now, it's not perfect because there still may be jurors sitting there thinking, I wonder if he pulled the trigger. Why didn't they put on any evidence that he didn't? But it's certainly better than nothing, and it would at least somewhat level the playing field when, you know, the huge burden is supposed to be on the prosecution. But they've flipped that. They've made it so we have no ability to test the gun. And that would go some ways towards fixing that imbalance. But at a bare minimum, Your Honor, we would ask this. Of course, we think dismissal or that other remedy is better. But at a bare minimum, we would ask that all of the, I guess I'll call it scientific, technical analysis of the gun that the state performed, that's Ziegler, the Haags, and so forth, be suppressed. And so under that scenario, the state would still be able to say, well, we think he was mishandling the gun in some earlier day, and so it must be that he pulled the trigger or whatever their other eyewitness evidence they think they have. Under that scenario, they could still present all of that, but all of this technical evidence would have to be suppressed. So that's our sort of third option, imperfect, not as good as the first two, but we'd ask the court to consider that if the court thinks the first two options are not warranted. So in short, Your Honor, I'll get up on rebuttal if there's anything worth rebutting. But this is an outrageous series of events. I don't think you will find a reported case with such an intentional destruction of a key evidence in the case without any effort to preserve it, even though it would have been the easiest thing in the world to disassemble the firearm and carefully photograph and measure the parts. They didn't do that. This is a classic Trumbetta, Youngblood, Chouinard violation, and we would ask the court for relief.
Thank you. First of all, my assistant wants to get on and tell you all what she needs on these exhibits. So go ahead. Whatever. Come over here. Just over here.
Can you guys hear me?
They're all muted. I don't know why
Yes,
they're
we
all.
can.
Okay, go ahead.
My name's Haven. I'm the court monitor, and even though you guys have a court reporter, I'm in charge of every single exhibit. So what I need is for both sides to send me a list of everything that was admitted. If it's in your email, then that's fine. I have all of your exhibits in the email. And then from here on out, there's not much I can do with an exhibit if it's not admitted or labeled by you, or if it's just like shown and published. I have no way of knowing.
All right, let me clarify. What you admitted was what you showed on screen. Okay, nothing else was admitted because you didn't move for the admission. You just put it up on screen. So that's what you need to identify as admitted. Okay.
Right. The one exception for that, because I didn't know if the court wanted me to put it on screen, was simply the email that I said, the affirmation that I said I was sending to.
Well, she stipulated to that.
Correct. But I just wanted to make sure the court knew that I intentionally didn't put that on screen and sent it
Okay.
to.
Ms. Morrissey?
I don't know that the defense went through and discussed and admitted exhibits A through Y. Is that the issue that
No,
you're
it's just
addressing?
like when you moved on from your bullet exhibits and you didn't admit like 14 of them, okay? It's only what was shown up on screen. All right.
So I just want to be clear, the exhibits that the defense did not put up on the screen are not admitted.
That's correct.
Yeah,
Except
I
for
mean,
the-
just to clarify, at the beginning of the hearing, that's why I said that, because I was trying to allow this to move smoothly, that, will the court deem the filings and the attached exhibits admitted for the purposes of this hearing? And Erlinda Johnson said that's fine with the prosecution. And so that's why I wasn't going through the procedure.
Oh, okay.
It's also
All
this-
right.
yeah,
You know what?
that's-
that sounds fine. Does that sound fine to you, Ms. Morrissey?
Yeah, and that was we expected the same of our exhibits.
Okay,
We
very good.
wanted that
All
to go both ways.
Okay, so we'll do the ones on the pleadings.
Okay.
What I'm telling her. Okay, all the exhibits in the pleadings. Now, way past what I had anticipated. You may have 7-minute reply, Mr. Bash, and I will time you on that, and I will cut you off. Okay, go ahead,
Thank you.
Ms. Johnson.
Thank you, Your Honor. May it please the court. Your Honor, pursuant to Trombetta versus California, it is the defendant's burden to demonstrate that, number one, the unavailable evidence possessed exculpatory value that was apparent before the evidence was destroyed. And number two, that the evidence is of such a nature that the defendant cannot obtain comparable evidence by other reasonable available means. It is their burden. And what you heard the defense argue is everything the state did and didn't do, but they didn't demonstrate by objective and independent evidence that the police or the law enforcement officers in this case knew, or this perceived exculpatory value of this evidence was apparent to law enforcement. So the defendants believed exculpatory value of the internal components of this firearm were not apparent to law enforcement, Your Honor. You heard testimony from Officer Hancock, Corporal Hancock, who said this gun appeared perfectly fine. There seemed to be nothing wrong with it. You heard from Mr. Ziegler. When he received it at the FBI, the gun fired 12 times, just as designed. There was nothing apparently wrong with this gun. So the defense now comes and argues that this accidental discharge testing that led to the damage of some of these components deprived the defendant of this exculpatory evidence. Well, that's not the way the test works. The mere possibility that this destroyed evidence could have been tested, could have exculpated the defendant, is not sufficient to satisfy the first prong of Trombetta. And that was clarified in Arizona versus Youngblood, 488 U.S. 51 at page 56, where the Supreme Court clarified the Trombetta test, that the defense bears the burden of demonstrating that this unavailable evidence possessed exculpatory value, but not just possessed exculpatory value, but that it was apparent to law enforcement that it possessed exculpatory value. And so I know the defense takes issue with the state's argument that they have to show through independent and objective evidence. And I'll tell you exactly where that is. United States versus Bull and United States versus Martinez. In United States versus Bull, which is 25 F 3rd 904 at page 911, the 10th Circuit, U.S. 10th Circuit Court of Appeals noted, and in that case, just to give the court a little background, I'm sure you probably already read it, Your Honor, the defendants were charged with, where they were tasked with building these radio tower legs and these radio towers. The legs had to conform to certain chemical specifications. During the building of these legs, they received FAA Quality Reliability Officer certificates that said they conform. But then, unfortunately, subsequently to their construction of these radio towers, one of them basically did not malfunction. It essentially broke. And so Mr. Bull and his business partner get charged in federal court. And they basically tell the government through their counsel, please preserve these tower legs. We have this certificate from the FAA quality reliability officers who certified that these tower legs conformed to chemical specifications. The government, on the other hand, had testing that they had initially sent off to the University of Maine, or the part of the tower leg they sent off to the University of Maine to have it tested. That test showed that they did not conform to the chemical specifications. So in this particular test, in this particular case, the U.S. 10th Circuit Court of Appeals found and actually held that the defense didn't meet Trombetta. They didn't meet, and the analysis in that case was under Arizona versus Youngblood, despite the fact that the defense had independent objective evidence. And the reason the state brings that to the court's attention is because at page 911 of that opinion, it says, second, Bell and Bowles' assertion, and I'm quoting directly from the opinion, second, Bell and Bowles' assertion that the tower legs possess potentially exculpatory value was not merely conclusory, but instead was backed up with objective, independent evidence, giving the government reason to believe that further tests on the leg might lead to exculpatory evidence. We don't have that in this case, Your Honor. And that was also noted, that kind of language was noted in the U.S. 10th Circuit Court of Appeals opinion in United States versus Martinez, 744 F. 2nd 76. And in that case, the defendant was charged with possession and making explosives. Law enforcement seized a package. They essentially removed the blasting cap from the device. They opened the wrapper and then they took the material, they burned it, and they buried it. They also transported other materials such as a manila envelope that contained a mailing label. But unfortunately, well, they actually processed that for fingerprints and they photographed it, but then they subsequently destroyed it. Mr. Martinez filed a motion to dismiss under Trombetta. The 10th Circuit Court of Appeals affirmed the district court's denial of the Trombetta motion and noted that the defense was merely arguing. So what the defense was arguing was the manila envelope could have been exculpatory, the mailing label could have been processed for DNA, for saliva on the mailing label to determine it was not Mr. Martinez. And in fact, they argued that there was no evidence that these items that were destroyed were even explosive devices. The 10th Circuit noted that other than conjecture and speculation, not independent objective evidence, the defense had not demonstrated that these items before they were destroyed were apparently exculpatory to law enforcement. Again, what we have here. But then you also have to look at the second prong of the Trombetta test, and that is, does the defense have other available comparable evidence that they could use in this issue? That is addressed by United States versus Ludwig, which is 641 F. 3rd, 1243, also a 10th Circuit Court of Appeals decision. And in Ludwig, the law enforcement officer conducted a traffic stop. They lost or destroyed the video that documented this traffic stop, and the defense filed a motion to dismiss under Trombetta. The 10th Circuit noted that Ludwig did have other comparable evidence that could be obtained by other reasonable means, and that page 1254 of that opinion, the 10th Circuit notes, we rejected defendant's Trombetta claim, reasoning that the defendant could have called witnesses to the event to adduce what the missing videotape evidence showed. They have that in this case. You have the officers who seized this gun. You have Mr. Ziegler who conducted the accidental discharge test. You have Mr. Haag, Luke Haag, Mike Haag, who can testify about their analysis and examination. The parts are still available. The fact that this gun was unfortunately damaged during the accidental discharge testing does not deprive the defendant of the evidence that they could use effectively in cross-examining, and we saw that. Defense counsel effectively used this information in cross-examining just in this motion hearing alone. It looked like he was doing it for a trial, but that right there demonstrated that they have other reasonable available means to get to making their point. So they fail under Trombetta. So then we go into Arizona versus Youngblood. Under Arizona versus Youngblood, the U.S. Supreme Court added a third test that in order for the defense to demonstrate a due process violation, they have to show that the that the law enforcement acted in bad faith. And at page 57 from the Youngblood decision, 488 U.S., page 57, it says that basically when you deal with failure to preserve, and I quote, evidentiary material of which no more can be said than it could have been subjected to tests, the results of which might have exonerated the defendant, the court has to look at the third prong, and that is that there was bad faith on the part of law enforcement. And that bad faith element actually dovetails with Trombetta's first element, which talks about what essentially law enforcement was aware of. So you have to look at what was law enforcement aware of in this case. And Your Honor, a dispassionate review of the evidence in this case leads one to conclude that the exculpatory value of this firearm in the condition it was in on October 21st, 2021 is extremely low. First, Mr. Baldwin himself told OSHA investigators that the gun had no mechanical defects. In fact, he was asked specifically, Corporal Hancock testified to that. He was asked, was there anything mechanically wrong with the gun? He said, no, there was nothing wrong. I'd been using it for days. The only problem was that there was a live bullet in the gun. Those were his words. That could not put law enforcement on notice that this gun had, if you believe their theory, some potential mechanical defects. When he was interviewed by law enforcement on October 21st, 2021, he never said, I didn't pull the trigger to the officers. He said the gun went off. Well, saying the gun went off is not the equivalent of saying there was something wrong with this gun. People say the gun went off because nobody was expecting that a live bullet would be in there. It's unknown. But what we know is that when somebody says the gun went off does not equate to there's something wrong with this gun. So there's no way for law enforcement to be put on notice that there could be anything wrong with this firearm. And the United States versus Bowl decision, Your Honor, was actually a good decision for this court to look at, because in that case, what you had, and the court did find a due process violation under Youngblood. They didn't find it under Trombetta because they, as I mentioned earlier, the defense did not demonstrate that it was immediately apparent at the time. But under Youngblood, they did find bad faith. And the reason they found bad faith in Bowl is because, number one, the defendants had this certificate from the FAA quality assurance officers that indicated these tower legs conform to chemical specifications. And then they asked the government, when the government seized the tower legs, to please preserve the legs. They begged the government to allow them to conduct testing on these legs. And despite getting these numerous requests, the government destroyed the tower legs. The court in Bowl did find that that is bad faith because they knew not only that they had the FAA certificate, they also were put on notice by the defendants. Hey, these tower legs conform to specifications. Nevertheless, the government destroyed them. That's not what we have here. What we have here is a gun that, to everybody who handles this gun, was in perfect working order. From the man who manufactured this gun, Mr. Pieta, to the person who received it after him, to the person who bought it from Matt, to law enforcement, to Mr. Ziegler, and all the way down to the Haags. I want to briefly just address this red herring that the defense raised about Mr. Haag's August 31st, 2023 report. First of all, Your Honor, there is no intentional wrongdoing here. Ms. Morrissey has accepted it was an oversight. She forgot to email it. But anyway, that's, I'm sure, the subject of yet another motion that's been filed before the court. But what's important there is that Mr. Haag in that report did not say there were modifications to this gun. What he said, there were irregular off-axis diagonal tool marks of an unknown origin. It seems unlikely, although it cannot be excluded, that these tool marks were made by the FBI's testing. So he doesn't say the FBI testing didn't create these. He clarifies that after he has an opportunity to speak and interview Mr. Ziegler about how he conducted that test. That does not equate, Your Honor, to bad faith at all whatsoever. That's a red herring that the defense is bringing before this court. The bottom line is that under Youngblood, under Trombetta, they fail. Under Youngblood, they fail. They cannot demonstrate bad faith because what is really important here is, what did law enforcement know? Law enforcement knew that they received no requests from Mr. Baldwin, from his attorneys. Hey, can we look at this gun? There may have been something mechanically wrong with this gun. There was modification to this gun, was a fortuitous offense that the defense developed after the gun was damaged, or not the gun, but the internal components of the gun were damaged by the FBI testing. You have a witness who in a pretrial interview stated that he saw Mr. Baldwin pull the trigger. That's Zach Sneesby. Mr. Baldwin's own statements that the gun was working fine. And what's also important to the court's analysis, Your Honor, and I know they try to discredit what the Bull decision said, but it is nevertheless in the Bull decision. At page 912 and 913, and I quote, moreover, courts have held that the government does not necessarily engage in bad faith conduct when the destruction of evidence results from a standard procedure employed by the government department or agency regarding the disposal of like evidence, at least when there is adequate documentation of the destroyed evidence. And so the defense says, well, that's just about when they destroy the evidence, when they're trying to get rid of it. I would respectfully submit that that's a narrow reading of what Bull says. What Bull says, and I will get to what Chenard says about that too in a minute, but what Bull is basically saying is they followed standard operating procedure here. You heard testimony from Mr. Ziegler that he conducted this test pursuant to standard operating procedures by the FBI. And so therefore, Your Honor, there is no bad faith. What is different about Bull is that the government had no innocent explanation. And that's all over that 10th Circuit opinion. The government could not provide the court with an innocent explanation of why they destroyed these tower legs after they knew all this other information about how potentially exculpatory they could be. So I would respectfully submit, Your Honor, that under the due process clause of the 14th Amendment, the defense has failed to meet their their requirements to prove both Trombetta and Youngblood. And I would respectfully request that under that standard that the court deny the motion. Now, with regard to the state law, under State versus Chenard, Your Honor, as the court is, I'm sure, intimately familiar with that case, there are 3 requirements: that the state either breach some duty or intentionally deprive the evidence must have been material, and number 3, that the suppression of this evidence prejudiced the defendant. I want to read a passage from Chenard because I think that the defense loses at the first prong. Under the due process clause of the 14th Amendment, the defense has failed to meet their requirements to prove both Trombetta and Youngblood, and I would respectfully request that under that standard that the court deny the motion. Now, with conducted this test pursuant to standard operating procedures by the FBI, and so therefore, Your Honor, there is no bad faith. What is different about Bull is that the government had no innocent explanation, and that's all over that 10th Circuit opinion. The government could not provide the court with an innocent explanation of why they destroyed these tower legs after they knew all this other information about how potentially exculpatory they could be. So I would respectfully submit, Your Honor, that under the due process clause of the 14th Amendment, the defense has failed to meet their requirements to prove both Trombetta and Youngblood, and I would respectfully request that under that standard that the court deny the motion. Now, with regard to the state law, under State versus Chenard, Your Honor, as the court is, I'm sure, intimately familiar with that case, there are 3 requirements: that the state either breach some duty or intentionally deprive the defendant of evidence. Number 2, the improperly suppressed evidence must have been material. And number 3, that the suppression of this evidence prejudiced the defendant. I want to read a passage from Chenard because I think that the defense loses at the first prong. What's important here is that these parts were damaged during a test that was done pursuant to standard procedure. The cite to Chenard is 1981 New Mexico Supreme Court decision at 96. At paragraph 16, the court notes that if I can just find where material is destroyed before its significance as evidence is realized, the defendant's inability to inspect or test it does not deny him due process. But right above that, they say, thus, if the substance in the present case had been used up during testing, the state would not have breached any duty and there would have been no due process violation. So what's that telling us? What that is telling us is that if a test is used up or damaged during standard testing, there is no due process violation because the state hasn't deprived the defendant of this evidence. That's what happened here. This was one of many tests that the FBI had available. They conducted this test pursuant to standard operating procedures. And if you look at the reasoning in Chenard and the logic of Chenard, that basically it's saying if the evidence is consumed during testing or damaged in this case during testing, the state has not breached a duty. And so the defense fails under the first prong. And the court's analysis should end there. But even if the court goes to the second and third prongs, the second prong is materiality. So as to this element, the defense has to show that the damage evidence, basically the court looks at the damage evidence and how it's affected by the weight of other evidence. Well, you have witness testimony who saw Mr. Baldwin pull the trigger. You have the numerous videos that Ms. Morrissey was playing for the court on Friday where that gun worked perfectly fine. You have an expert who actually watched every single one of those videos and said that gun appeared to be working perfectly fine. You have expert after expert who said, even if you assume that those diagonal lines were there, that gun, would not have affected the functionality of that firearm. So the second factor or element that the court looks at in determining whether it's material is the opportunity to cross-examine. And that's right from Chenard. They have ample opportunity to cross-examine. The defense, you have capable defense counsel representing Mr. Baldwin. They will absolutely take advantage. And we saw in the last couple of days that they have taken advantage of these issues and can ably and vigorously cross-examine the witnesses about these tests that were done on this gun. And number three, the defendant's use of the loss in presenting his defense. Again, that goes with number two, they can make very effective use of this testing and what happened during the testing. And the parts are still available, Your Honor. In fact, they had somebody go look at this evidence. He's a retired ATF agent. Go look at these pieces, these items from this revolver back in end of April, I believe. But we didn't hear from that expert, and it's their burden. And finally, Your Honor, with regard to the last prong, and that is prejudice. In State versus Bartlett, 109 New Mexico 679, the court noted that prejudice has two components. One, the importance of the missing evidence to the defendant, and number two, the strength of the other evidence of the defendant's guilt. There is ample evidence of the defendant's guilt in this case as it relates to his conduct, his reckless conduct, and this claim, self-serving claim that came months after this unfortunate tragic event of October 21st, 2021, does not mean that this gun had been modified or this gun discharged on its own. There's evidence to show quite the opposite. So there is other strong evidence of the defendant's guilt in this case. Your Honor, they have failed to meet their burden as it relates to the U.S. Constitution and the state constitution, and we would respectfully request, Your Honor, that the court deny this motion in its entirety. Unless the court
Thank you,
has
Ms.
any
Johnson.
questions.
I do not have questions. Thank you very much. All right, reply 7 minutes.
Thank you, Your Honor, and I'll try to beat that. One quick housekeeping clarification point. When I said our narrowest remedy would be just suppression of the technical evidence and they could bring it in other ways, I, of course, did not mean to forfeit independent objections to whatever other evidence they might bring in. I just want to make sure that's clear. Ms. Johnson said we had the burden. We satisfied that burden under Trombetta and Youngblood. I would just note from the court that Choynard, and I'm sure I'm mispronouncing that, said when the state shows that it acted in good faith, Then you go to materiality and prejudice. So as we read that statement, it does not put the defendant on the burden on good faith. We heard very little about Youngblood and bad faith in that submission. Ms. Johnson spent a lot of time on Trombetta. As we've noted today, the easiest resolution of this case is under the bad faith prong of Youngblood and New Mexico law. Youngblood requires only that the evidence be potentially exculpatory, meaning that tests might have indicated that it was exculpatory. We clearly satisfy that. On bad faith, I mean, it's hard to see how the state can contend that there's no evidence of bad faith here. They knew months before they ordered testing that they knew would destroy the gun, that he was claiming, and that other witnesses had claimed it just went off. They have provided no reasons why they didn't disassemble or photograph it, none. You didn't hear any answer in that presentation on why they didn't at least preserve the evidence through photographs. You've heard no defense of the mallet test. They can't, because their own expert, Mr. Haag, says it was pointless. You've heard no defense of why they didn't run the push-off test when it was still possible to do that. And they hid the exculpatory report for months. And again, that report is exculpatory because it provides evidence that someone other than the FBI had modified this gun. So what does all that mean? Two things. One, we can never use our own expert to examine the original state of that firearm. It's not fair that a criminal defendant doesn't get that opportunity and the state did through Mr. Ziegler. That's not fair. That's not how criminal prosecution is supposed to work. Second, because of this late Haag disclosure, we can't even really scrutinize the Haag's analysis with our own expert because they disclosed it a few weeks before trial. I mean, it's just outrageous. This is not how criminal prosecution is supposed to work. It's not in keeping with the duties of the prosecutor. As expected, Ms. Johnson said, well, this was just standard operating procedure. It's not. They have no explanation for the fact that it was the sheriff's office that requested this testing and did not tell Mr. Ziegler the circumstances, did not tell him that no blunt force object had impacted this gun. There is no FBI manual that says in these circumstances, he should hit the gun with a mallet many times until it breaks. There is no standard operating procedure. And if you listen to the quote she quoted from Bohl, which is their case on this, it said that that's about disposal, one, and that is only an exception when there's adequate documentation. That was in the quote she read. None of that's satisfied here. Finally, Your Honor, she said under Trombetta or under New Mexico law, you know, there's comparative evidence because we can cross-examine somebody. But I heard no response to the problem with that. There's no one to cross-examine because nobody took the time to open the gun up, look at its parts, take measurements before they destroyed it. It's like the Zaragoza case. There's no one to cross-examine. And I'll just end with this and then a quick sum up. I heard again that the parts are still available. They are not still available. There's a picture in the record, I believe it was Exhibit L. The full cock notch was sheared off and it is not available because they destroyed it and they rendered it unavailable for the defense. That is just not accurate. It is not available. So with that, Your Honor, again, this is an egregious constellation of facts. There's clear bad faith. The evidence was clearly apparently exculpatory because that's the entire reason they did this test, to try to disprove Mr. Baldwin's exculpatory statement. With that, I'll put it in the hands of the court. Thank you.
All right, thank you. The court is going to put this in a written order, and it will be the court's decision, and it will be filed sometime Friday. I will tell you this, I will not take any supplemental briefing on this. It will be discarded. We're done arguing this case. Do not give me a supplemental briefing whatsoever on this motion to dismiss the indictment based on destruction of evidence. I'm going to move on to the scheduling order because today is the pretrial conference and docket call. It was also the deadline for the plea. So the docket call is only to determine whether you're going to trial. And obviously you would have told me you had a plea today and the deadline is today. So we're going to continue on with our jury selection on Tuesday, the 9th, and then we're going to carry on with the trial 10th, 11th, 12th, 15th, 16th, 17th, 18th, 19th of July. Okay?
Yes, Your Honor. We have a hearing on the motions in limine on the day before jury selection, as I understand
Yes,
it.
yes,
And
you do.
right. And I understand that that will be, my understanding is that that will be in person, which of course we would prefer if that's what the courts understand. Obviously, it's the court's decision, but that's what we were hoping.
That's fine. I prefer in person. Ms. Morrissey?
Absolutely.
Yeah.
Okay.
And then one other thing that's in the scheduling order that I think I should bring to the court's attention, which is, yes, that is the schedule, but you told us that if there's anything that causes an issue to bring it immediately to the court's attention. The state has disclosed 44 witnesses, including 13 expert witnesses. And I don't know what to say to the court other than I don't know how we could get through 1/5 of that. And so I don't know whether that is just an attempt to make this process unfair or whether they intend to call 44 witnesses and 13 experts, but they have disclosed that for an 8-day trial, and it doesn't make any sense to me. And so I wanted to alert the court to that.
Ms. Morrissey?
Your Honor, I have always had some concerns that we did not have enough time to try the case. I will also say that the defense has filed extensive witness lists, and I think their witness lists total 25 or 30 witnesses. So I don't know whether they're intending to call those witnesses or whether that was just gamesmanship. But if at the end of the day, this is a 50 witness trial, we will not have enough time if we have to stop on the 19th. So I would ask the court, if the trial goes beyond the 19th, I mean, does the court have time to take us all the way to, let's say, the 26th of July?
Your Honor, the
This-
defense.
No, no,
Wait,
just-
wait, would you stop?
We're doing the 19th. You all said the 19th. Both sides said the 19th. I can play back the log notes. Both of you said this should be fine. Okay? I will split up that time frame. We can certainly put you on a clock, but we can talk about how much time you're going to craft here.
Well, Your Honor, one of the reasons that we filed a motion for an exhibit list is so that we don't have to spend all of our time in trial having the jury out of the room while the parties argue the exhibits. And of course, I can't get the defense to agree to just file an exhibit list because they feel like they're turning their hand. And quite frankly, even if you ordered an exhibit list, my guess is they're going to have every single Pell video on it and every single Rust movie set video on it, and that's just going to be a sham. So I'm trying to come up with some kind of a way to try to get the defense attorneys to behave in a manner that would enable us to, at least to a minimal degree, work together on procedural issues. I've never been able to quite make that happen yet in this case. If we are objecting to exhibits, every time one of the lawyers tries to enter an exhibit into evidence, this case, not only is it not going to be done on the 19th, it's not going to be done on the 26th. And I will tell you, Judge, that while I appreciate the court's position with regard to the timing going up to the 19th, based on the cross-examinations that we have seen, in particular from Mr. Spiro, there's no way this case will be done by the 19th, and then we're going to find ourselves in a situation where if the court tries to shut Mr. Spiro down, who's by the way famous for this kind of conduct, then if you do that, then he's going to start complaining that the defendant hasn't had an opportunity and you're violating his rights and so on and so forth. So I'm trying to nip this in the bud right now. I'm not getting very far. We're not going to be done on the 19th. I mean, the state certainly would be done on the 19th, but the defense has they've got all the top brass from the sheriff's department on their witness list. I don't know why they're calling them, but they're on their witness list. So I'm not sure what to do about it. With the current situation, we will not be done on the 19th. I'm not sure we'd be done on the 26th.
May I respond, Your Honor?
Yes.
We haven't filed our witness list. They filed their witness list. Their witness list is 44 witnesses. Their list has 13 experts. Our list in our case will take, I would think, approximately a day, maybe 2 maximum.
What did you say? Your case will take a day?
Correct. Our case is not going to be a lengthy case. It's my prediction. I'm, of course, a defense lawyer. They have to go first. They have to prove their case. Okay. Second of all, I will tell the court that what I did in this proceeding with objections and how hard I fought the admission of exhibits is actually a pretty good reflection of my career, which apparently Ms. Morrissey knows so well. I haven't had any problems to date. And the reality is I don't intend to object very much. And I have a feeling I'm not going to have that many objections to that many exhibits as long as they comply with the rules of evidence. I don't really do very much other than ask questions. And if witnesses tell the truth, the examinations are shorter. And when I have something like what happened with Mr. Haag, of course that took longer, and as well it should have in a matter of this importance. So I think you have a good sense for how we're going to conduct our defense. But a lot of those statements are just inaccurate, right? We haven't even filed a witness list. It's her witness list that has been filed. It's 44 witnesses and 13 experts. And I would urge the court to consider that and ask yourself, is that not gamesmanship? It's not on me to design my case first. It's on the prosecution. And prosecutors have a duty that has been totally lost in this case. And totally lost in this case from the grand jury on through. And we keep watching it and we keep seeing it. And at a certain point, you can almost play back in your mind the kinds of things, the game. So
right.
that's the record I want to make.
All right. So I heard you say 1 or 2 days for your defense. For the
Correct.
defense's case. All right. So with 8 days of trial, I'm going to give Ms. Morrissey 5, and I'm going to give you 3, with the possibility of you being limited to 2 and Ms. Morrissey being given 6, just on how things are going with the cross-examination and things like that. Okay?
I don't know. I don't know if I totally understand the court, but but it's the ultimate outcome of what the court is saying is fine insofar as obviously to the degree I'm Miss Morrissey, whatever she wants to call me, I am going to want to cross-examine the witnesses. I'm sure
Right.
Your Honor's going to want to know the truth, want the truth to come out in that courtroom
Right.
also.
This
And
is
so as
what I'm
long as I have an opportunity to cross-examine the witnesses and the court does not allow cumulative witnesses and testimony,
Right.
then I don't think that the schedule was a problem. And
Right.
and just for, yeah, and I'm the one alerting the court. I'm not the one who disclosed 44 witnesses and 13
Right.
experts.
Okay. All right. In my experience, they don't use all those witnesses. I'm sure that's your experience as well, too, both of you. Okay.
Well-
So what I'm trying to make clear is this, is that I'm really relying on your 1 to 2 days. Okay. So, but I don't also want to be in a situation, Mr. Spiro, where you say, well, now we really need, to really go into our witnesses and things like that based upon the state's case. So at this point, it's going to be 5 and 3. However, depending on how long these cross-examinations are taking and how fluid we're going with the state's case, then it's going to be 6 and 2. Okay, I'm letting you know
Understood.
they're going to get that many, and you're on notice of that, and I'm not going to move this into the 26th. I have plenty
Yeah.
of other obligations to other defendants and the prosecution.
I understand that, Your Honor. And so just to answer one question the court rhetorically posed to me is no. In an 8-day trial, I am not, other than if a prosecutor is playing games and trying to get an improper strategic advantage over defendant. No, I have not seen 44 witnesses and 13 experts disclosed in an 8-day case. And it is nothing other than the tax that these prosecutors take. And I've never had issues with other prosecutors like this. And because of my career being somewhat public, you would know, and Ms. Morrissey would know, and it's never happened. It's only happened in this case. And so the reality is what we're going to ask for is the court to have Ms. Morrissey give a realistic, fair witness list and expert list to the defense so that I can then quickly tell you all what my witnesses are going to be in response to those witnesses and the exhibits. They go first.
You have a
That's how
deadline on
this
your
works.
witnesses anyway.
We do, Your Honor, but this doesn't accomplish what the spirit of the court's order and the spirit of the way this is supposed to work is the prosecutor tells us what their case is going to be. That's why they go first. That's why they have the burden of proof. That's how this works. And then the defense does their case in response. Obviously, I can't tell until the state rests exactly what we're going to do. And so it's unfair to the defense, and the court should not have this kind of gamesmanship to allow them to disclose 44 witnesses, which is not a realistic assessment of their case. It's literally done to hide the ball. The court knows that. I know that. The 13 experts are obviously duplicative and absurd. The court knows that. I know that. And so I urge the court to not allow them to do that. And that's not the spirit of this order. And
Right,
as I
okay,
talk to
okay,
local,
all right, okay. Ms. Morrissey,
I'm not modifying my witness list, and this is why. If during trial I decide I'm not going to call this person Instead, I'm going to call this person. If I remove one of those people now, these people are going to go up in arms and say, Judge, that person wasn't on her final witness list. It leaves me absolutely no flexibility. And I can tell you with these lawyers, that's something that I need most. Mr. Spiro can complain all day, but the truth of the matter is that we have in good faith gone to the defense and said, hey, there's a terabyte of discovery. Will you guys agree to just to a deadline to file exhibit lists so that we know what you're going to be using and you know what we're going to be using? No way. That tells you where these people are coming from. They are not going to cooperate. They're not going to do it today, and they're not going to do it 2 weeks from now.
Okay, listen, I don't know where, you say this is really surprising to you, Mr. Spiro. This is not surprising in New Mexico. If you look at the witness lists of the prosecution, this is normal. So I'm not going to make her reduce them. I have seen, even in the Hannah Gutierrez trial, that they immediately disperse the witnesses, say, I'm not going to call these 5, et cetera, et cetera. That may not be your best scenario, but that's how it's going to go. I'm not going to make them, everybody, you too, I'm not going to make them eliminate that. Your witness list is due.
Understood, Your Honor. And I understand the court's directive. I would only ask that we be given 48 hours notice on witness order. That's all I'm asking for, with that many witnesses in 8 days.
You need 24 hours on witness. At the end of the day, we're going to do what we did before. At the end of the day, they're going to tell you who they expect to call the next day.
And I will do my best, but I cannot guarantee the order of witnesses if I've got people flying in and planes get delayed. And this,
it'll be reasonable.
Here's the other issue that could create delay. I believe the court is intending to have voir dire last for 1 day. It is my guess with this group of defense attorneys, that's not going to happen. So maybe we want to address that, because if voir dire goes into 2 days, 2.5 days, we got problems.
I've never not picked a jury in 1 day. I can't
Right.
imagine that this would be the first time.
And by the way, I don't know. We went into private voir dire. I don't know if it's going to require both of you to want to do that, and the court. It depends on how things are going with the jury and whether anybody's going to likely taint the jury and we need to go private. But the other thing is we're calling 39 at a time. And so there's not going to be 79 waiting. There's going to be 39, and we're going to get the next 39. And that way you are going to be able to formulate on each panel, whether we need to the next panel.
That makes sense and understood, Your Honor. Final issue from me is authentication. We have proposed, and this is another thing that I would urge the state and the court, to simply agree to the authentication of police records, police lapels, 911 calls, those things that the state produced, official police records. State has not agreed to that. Any caveat that I give on how long my case or my crosses take depends upon that. I don't want to be, and no prosecutor has ever made me require somebody to then sit there and watch it and say, yes, this really is, and the jury goes out of the room and this and that. All I'm asking for is an authentication stip for police records, police recordings, and official documents of the state of New Mexico.
All they need to do, we would have agreed to this weeks ago. All they need to do is tell us which exhibits they want us to stipulate to. Instead of doing that, they sent an email that said, will you agree to stipulate to every single lapel video? My response is no. And this is what prompted our motion for an exhibit list. Because what they want to do is they want to say, will you stipulate to the Rust videos? Will you stipulate to the lapel videos? I'm happy to engage in stipulation. Tell me what you want me to stipulate to. I will do the same, and then things will go smoothly. If these people will not tell me what they want me to stipulate to, Kari, we want to get this video in and we want to go from this minute to this minute. Do you have any objections? Should there be any redactions? Let's do it. They won't do it.
All right, listen, I'm ordering you all to go through and see what you can stipulate to, and I want that stipulation before me on the motion in limine day, which is July 8th. And how many, with respect to exhibits, let me hear why you would not want to stipulate to exhibits, or at least have them known ahead of time.
Oh, I'm perfectly happy. I think the word stipulate and the word authenticator being merged here. What we asked for was an authentication stipulation, just as authentication.
Okay, authentication stipulation. That's
that
due,
seems like,
that's due in the motion in limine day.
okay. The
Okay.
second thing is, well, we have their witness list and their exhibit list. I'm happy to, as I do in all of my cases, provide a list back to them. I'm happy to do that. So I'm not opposing providing exhibits prior to the motion of limine day. I'm not objecting to that at all.
Ms. Morrissey.
They filed a response in opposition
all
to
right.
our
Listen.
motion for an exhibit list.
I
What is
got
he
it. I
talking
got it.
about?
I'm relying on Mr. Spiro. Okay. So when can you exchange exhibits?
As soon as I have the state's exhibit list, we can respond within 48 hours.
Why can't they be simultaneous? They tell us their
No,
exhibits.
no,
we
no,
tell them
okay.
ours.
No. You know what? I'm not going to referee everything. Okay. You all are going to do things professionally and in good faith. So get your exhibit list out, Ms. Morrissey, and then in 24 hours, he will get his exhibit list out.
Okay, let me give a deadline then for my exhibit list. I'm not
Okay,
prepared.
I'm gonna summarize this. Okay, so stipulation on authentication of exhibits that the defense wants in. What about, and I don't think the state needs that.
And I will agree to those things if they tell me specifically the pieces of evidence that they want me
You're
to
going to have
stipulate.
to, Ms. Morrissey, because they're
Okay.
going to have to file it on July 8th. No, where is it?
We need
Yes.
to know their exhibits way before July 8th, and they need to know ours. July 8th will leave
think so?
everybody hamstrung. We'll still be arguing during trial.
Well, what I would, okay. So let me just divide this into two things, and I think perhaps the court will think this is a reasonable. July 8th is the motion in limine day. Is that okay? So the first thing, which is completely separate from everything, is just authentication. I'm going to ask for an authentication step. If the prosecution will not authenticate their own police documents, I will email the court and explain that. Okay, and I've never seen that before. Second thing is on the exhibit list. If they give us their exhibit list on Friday, okay, I've messed up my on June 28th, okay, we will provide our exhibit list on July 1st.
Why don't Mr.
All right,
Spiro?
all right, here, listen up. The authentication stipulation is due Friday. Okay,
Understood.
so that means that there's going to be a stipulated order that I'm going to sign on authentication. So the Ms. Morrissey needs to see that no later than get that to Ms. Morrissey on the 26th, and then Ms. Morrissey, I want you to look at it and you know, if you can't stipulate to it, then we'll have to address it later, but I'm not going to have a hearing on it. Okay.
Yes.
All right. So that needs to get in. So show it to Ms. Morrissey on the 26th, the proposed order or the items you want stipulated, authenticated to. Then for the exhibits, why don't you give them to him July 1 and you give him your exhibits, Ms. Morrissey, on July 1, and he will give you his exhibits on July 2nd. Okay.
That works.
All right. All right. And then, yeah, I'm not worried about being able to pick a jury in one day. I think we're going to pick a jury even before by the afternoon, but okay.
Yes, Your
Did
Honor.
I miss anything? I'm aware
I-
of these. I'm aware of these motions. I haven't decided what to do with them yet.
So
Yeah, and-
understanding that the court has set exhibit list deadlines, we withdraw our motion for an exhibit list based upon the court's ruling today. The state will submit an order to the court indicating that the deadlines are the
Fine.
1st and 2nd.
Perfect. Okay, what else? This isn't going to get continued. And even though I'm going to get that order in by Friday, do not think that that means stop working for trial. Hello, you've seen Frozen.
I'm not frozen, Your Honor. The only thing else that I would say, and I once asked to approach Your Honor in this forum, and Your Honor said, I don't know that that's possible. But any guidance, I mean, one thing that can reduce the court's time and maybe simplify this, if any guidance that the court were to have on any of these issues, you were able to, on a teleconference or otherwise, give us all a heads up. So for example, and I don't want to pick on the state, but if you were to say there aren't going to be 13 experts, okay, or you were going to tell me that certain parts of this case, we're not going to have a civil negligence case about how movies worked on Westerns in the 1950s. I mean, that would help, and you would have less motions in limines, and it would force the parties to So and that would be an ask from the defense, and I think it would end up being a blessing for the entire proceeding and for the court's time.
Well, what I'm hearing is you want her to, you want the court to tell her to limit her witness list. Is that
No,
right?
I don't mean that one. I just mean on any issue, frankly. It's
Oh.
not that. I mean, we talked about that issue. I just mean if the court had guidance, say at some point in a 10-minute teleconference saying, listen, I've looked at this. I'm not deciding the motions to eliminate. I'm not deciding things, but this is how I see this going. I think it would do a world of good and pushing the parties to simplifying this matter so that we can have a fair trial in front of a jury. And
Okay,
get
so
some
what I hear you say is, can we without this public forum, you go first, you go second, you go 3, 4, 5, that if the court's inclined to do this, it's by email,
Well, the court can do it however
conference, or by conference?
yeah, or teleconference or whenever the court wants. The court can give guidance right now in front of whoever. I don't know if anybody's listening, but if anybody's listening,
I
you
feel
can do it
sorry
right.
for them that they're missing dinner. Yes.
Yeah. So you can do it now. I'll take guidance. I always take guidance from the court. But if the court would want to have a more informal proceeding, I think
I do not want to have that because I do not want, because everything is appealable and it's got to be on the record and it's got to be.
Understood.
I just want to put this on the record. The state has the burden, so I'm going to need to call as many witnesses as I need to call in order to try to meet that burden. I can't just cut my witness list in half.
Nobody's
That's
asking
where I'm
you,
gonna be.
nobody's asking you to. I'm giving you 5 to 6 days and that's plenty. Okay? All right.
Thank you, Your Honor.
It's not anybody's first rodeo. Okay? All right. Have a good evening. And
Thank you.
please, the press is going to hound, where's this order? Where's this order? Please don't participate in that. Every order will be at least by Friday on these pretrial motions. Okay?
Thank you.
All right. Thank you for your presentations. We're in recess.
Thank you, Your Honor.
Thank you, Your Honor.